meeting to order. I'll advise each of you again to turn your cell phones off if you've got them on. Usually where I can't hear them, please. Would you rise for the invocation and remain standing for the pledge of the American flag? Father, again, we ask for your presence to be felt here this evening. We pray for your wisdom to be given to us, that each and everything that we consider as a board today might be that which would be the best that we can do for Effingham County as we've been entrusted. In Jesus' name, amen. I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Alright, first item, consideration of a resolution to approve the agenda, please. I'm told that we have some items that might need to be added.
Mr. Chairman, we have two potential items for consideration. One was tabled at your last meeting until August the 6th. It was actually tabled with a specific date. It has come up since then that we may need to address that prior to that meeting. And I think Mr. Godwall has maybe some opinion on if and how that can be handled by the board.
Yeah, it's unusual because it was taken to a date certain of August 6th. And typically, I would not recommend you addressing that item earlier. However, as you know, the Open Meetings Act is what controls what you can add or not add in the meetings. And what it says is it becomes necessary to address an item at a meeting when it wasn't on the pre-published agenda. You have the authority to do that. I would not generally recommend it when you have tabled it to a particular date. Even though this item doesn't require a public hearing, I do think there were people here, representatives from some of the city law enforcement agencies may have been here when it was tabled and may not be aware that it's on the agenda tonight at a
Which item is it?
The maintenance agreements for the towers and the MAC. And basically what happened, that agreement expired July 1st, and obviously August 6th is after that. There was a 30-day grace period that Motorola gave us, and I think there was some discussion prior to the meeting of them allowing it to go to the 6th. There's been some lightning strikes and some other things that's getting them a little antsy to go ahead and get that back in place.
Well, I remember asking Wade at a meeting, he said he could make that happen because we discussed the few days of lapse.
Yes, sir. And again, since then, and Mr. Myers here, he may can explain exactly, they've become more concerned due to recent, I think there's been 2 or 3 strikes on the tower since that time.
But what's being asked of us to not have it, it's on here for tonight and to move it.
Add it to the
No, it's not on here tonight. They're asking to add it back even though it was postponed to August 6th.
The board voted to postpone to the 6th, and what we're asking tonight is if the board so chooses to add it through whatever means we do that, so that it can be acted on.
Point blank, is there a reason that we cannot wait until the next meeting as it was tabled to? Is there a reason we cannot wait?
Usually I would say, let's just go ahead just for simplistic reasons, but there was 2 reasons why I wanted to try to get with Toss and try to get this back up. One, Motorola has said, depending on what we do with the entire $1.8 million infrastructure, if this maintenance contract goes in lapse, it could jeopardize some of our finance options if we choose to go through Motorola. So that was one. The second one was a lightning strike that we just had at the MAC Tower, which caused $15,000 worth of damage. That was covered under the maintenance agreement. As soon as the end of the month hits, August 1st, we will not be under maintenance agreement anymore. Right now, we're under a grace period.
And I think
Was it your intention that, was it just a misrepresentation that we could wait until next meeting?
We specifically asked that question of Motorola, and none of that was mentioned.
Yeah, that's what I'm trying, Was it first thought that it wasn't urgent, and now it has become urgent, or was it just a misstatement that we could put it to the next meeting rather than this?
That is part of it. We've had so many meetings on the radio agreements and the infrastructure itself. We were under the inclination that this was a package deal and it could move on. Come to find out since the last meeting, that was not the case. It should not have been tabled that far. It should have only went to this date, which is the 23rd. And as chairman, I'll take full responsibility for that.
Does the board have information that if we choose to take this up tonight, that we can make an adequate consideration of the item?
See, that's one of my concerns is we haven't even had anything to review, so we're gonna be asked to look at something really quick.
It's the same agreement with a price reduction, actually. It's actually, well,
There's actually some explanations in that. The same agreement that you had that was tabled, $186,000, that same agreement is actually here again. However, there is a new piece to this. That agreement for $186,000 covered all the systems, 7.1, 4.1, and the 911. And looking at this, there is no reason, in my opinion, there's no reason to pay for a 7.7 maintenance agreement if we're not using that system. It is offline. Therefore, instead of $186,000, it drops to $126,000, $128,000. It's a savings there, but that is a new piece. It is a new agreement that I would actually recommend that you approve instead of
Is
what
it
you're
not
comparing.
true as well that all of this is going to become redone as soon as we enter into these new agreements?
Actually, the new agreement that I have, the 4.1 system and the 911, is what we currently have now. We currently have maintenance agreements on them now. They are subject to lapse now. When we redo, or if we redo the infrastructure, there'll be a new service agreement at that point just for that system, but not for these.
So this agreement, if we consider it this evening and act upon it, is basically going to go away and be rolled into a new agreement at such time as we upgrade all the systems?
No, sir, these will stay intact
These will
on their own.
stay.
Yes, sir. The only way that this agreement would go away is when we upgrade. If we do a county-wide and then drop the 4.1 system, there would be no need for us to have a maintenance agreement on that 4.1 system, obviously, because we wouldn't have it. There's been talk of having that as a redundant system, or either, and then you have the 911 system, which will stay intact anyway. So these two sections of this agreement will stay intact until next year.
Well, refresh my memory, what was it, why did we table it, there was some information we were waiting on, right?
There were 4 sections altogether: the UPS, the grounding, the infrastructure, and the maintenance. And it was kind of a group deal. We brought it all to you at one time. The UPSs we could handle then. The rest of it, we figured it was a group, we could push it on. And that's why everything got tabled, because Motorola's not giving us the information until July 26 on the infrastructure.
We're almost getting to the point of discussing the item right now. Yeah.
Exactly.
What I'm afraid to do though is add to the agenda. You know, if the reason we made it date specific was because of the information we had to have. But since we made it date specific, now that we've added, if we add this to it, then none of us have looked through this. And we're kind of trying to rely on memory.
And none of us have literature here today to look whether now.
But I mean, we haven't looked at this, and you know, in Wade, the Motorola rep, assured us that the few days would be no problem. He had that covered. So if we had made it not date specific, it probably wouldn't bother me so much. But since we did,
Frankly, I was trying to get it as much done as possible, and we were kind of pretty much led that it wouldn't be a problem to wait.
Correct. There's a couple of items that have come up at the last minute with this, but this one here was so important, I thought that we really need to get it back in front of you, at least so you can consider whether or not you wanted to add it or not.
But did he not tell us that they would cover through a grace period until that next meeting? I mean, we specifically asked that question.
He made a comment, he said if something happens, we'll be there.
Right. And since the last meeting, I did speak with them again, Motorola specifically, and said this was tabled till this date. And I wanted to reconfirm that with them, and they said, no, you will be out of your grace period. It's best to go ahead and get this on the July 23rd meeting if we can. Now, we are a valuable customer to them. So if we run out, I can't guarantee that they will cover us, though, because if you own a business and you're going to subject to eat $20,000 in damage because of a lightning strike, and you have the option of backing out What would you do?
This agreement is with Motorola, not Savannah Communications, right?
That is correct. It is Motorola, but they use Savannah Com.
Wade is Savannah Communications.
He is Savannah Com, correct.
So what he told us was not correct.
I wouldn't say that. I would say it would depend on his timeline.
It's basically like, this deal is with Ford, and we're dealing with the dealer for the vehicle. And it's a Ford warranty we're talking about.
Well, if they can't represent them, they don't need to represent them. You'll be able to count out said in the meeting, that's for sure.
Eric, it's my understanding that it's not a good idea, but we're not breaking a cardinal sin if we decide.
Then the other way to handle it would be, it would be preferable in the sense it would give you more time, you could have more time to review it, would be to have a special call meeting. I hate to suggest that because I have how much time you spend in meetings.
I understand. That's okay.
But that would, at least partially cure the issue that there may be people here who thought it was going to be addressed on the 6th.
Personally, this is going to be a long deliberation item, I think anyhow. I would rather have a special call meeting to discuss.
I'm okay with that.
Rather than to pick something up here tonight and make a half.
How soon do we have that? Would advertise for a while?
24 hours notice, right? All right, what's the other item y'all want to add to the agenda?
The second item, Mr. Chairman, is at approximately 10:25 this morning, we were served with a dispossessory notice on a building that we currently lease. And we have 7 days to respond to said notice, and I believe that I need the board's input on how we want to respond to that. So, again, we received it this morning at 10:25. We have 7 days, it won't wait till another meeting. Unless you'd like to have this
Is
for
this
call
not
meeting.
legal, this is legal that we can take up an executive session?
Yes, it is.
This does not need to go on.
Never mind, Mr. Chairman, I regard the request.
Okay. So,
Under what category would it be?
Depending on the occasion, dispossessory action.
yes. All right, so I'm still looking for a consideration of a resolution to approve the agenda. If the board members feel that we can handle this other item in a special call meeting, then I will entertain a motion as to how to deal with the present agenda. Or if you feel that we should add it, I will entertain that motion as well.
I'll make a motion to accept the agenda as written, and then have a call special meeting to cover those items, Mr. Martin.
Second.
I have a motion and a second. All in favor?
Aye.
Any opposed? So carried. We will discuss the time of that special call meeting in a little while, if that's okay with y'all. And Stephanie, I would like the record to represent the fact that Commissioner Loper is not present for this meeting and he's out of town on county business. Next item, consideration to approve the minutes for the July 8th, 2013 investment and budget workshops and the July 8th, 2013 commissioners meeting. There's no questions on them, I'll entertain a motion.
I'll make a motion to approve the minutes as written.
Second.
Have a motion and a second. All in favor?
Aye.
Any opposed? So carried. Motion, minutes approved as written. I think we can take care of the Consent agenda. Consideration to approve the second reading of the timber operations ordinance. Number 2, consideration to appoint an individual to the position of ACCG Irma Safety Coordinator and CWIWCG Safety Coordinator, and to approve for the chairman to sign the safety verification form. And number 3, consideration to approve the submittal of the EMPG response and recovery grant pre-application concerning EOC upgrades. Item number 4, consideration to dissolve the Effingham Resources Council. Item number 5, consideration to approve Winfield Pump Station sales agreement with Heritage Bank of the South and authorize the chairman to execute closing documents. Item number 6, consideration to approve an execution and transmitting letter to Chatham County Assistant Engineer Leon Davenport in reference to Benton Boulevard, Effingham Parkway. Item number 7, consideration to approve change order number 5 with Baker Infrastructure Group along Augusta Road, Phase 2A, 2B, and signal improvements. Number 8, consideration to approve the aging services contract with the Coastal Regional Commission of Georgia Area Agency for 2014. Item number 9, consideration to authorize payment of funds to the City of Springfield for the general fund using fund balance and approve a budget amendment for the transaction. Y'all will notice that the consent agenda has gotten a little bit longer. It was decided in our last meeting that several items could be dealt with consent agenda. If there's any items on there that the board does not wish to take action on collectively, it can be removed from that consent agenda item and put into general discussion. Am I correct in that statement?
Yes,
Yes. So if there's no questions, I'll entertain a motion on the consent agenda item.
Make a motion that we approve the items on the consent agenda as listed
In both?
in both, unless somebody has something on the floor.
I'll second.
I have a motion and a second to approve the consent agenda in bulk. All in favor?
Aye.
Any opposed? So carried. First item of old business, consideration to approve the request from the Lee Group for a refund of taxes for the 2009 tax year on 40 lots in Summer Place subdivision. As I stated before, I was on the board of equalization at the time this was heard, but since this has already been discussed by the board, I made that statement just for the information purposes. I think the board is looking at whether or not to actually issue the refund because of the time constraints of the payment, not as to whether it's an issue of fact. So I will sit here while this board determines that.
Ruth Lee.
Sir?
For clarification, it's my understanding you were on the Board of Equalization that heard the 2010 appeal, and just for the...
That is correct.
This involves a refund of 2009 taxes.
The taxes were paid in 2010. Or 2010, paid actually in 2011 when we filed the petition in the Superior Court.
I think they're just trying to clarify that there's not a conflict on this case where they'd be sitting on the board during this.
Yeah, I understand.
Right, and I think there is.
I think the tax commissioner is present, and maybe we need clarification to the dates and times of the payment.
Okay. I went back and looked to verify with my own eyes, and Ms. Lee's, the 2009 taxes were paid in April the 2nd of 2010. And that's on we went back to all 40 lots and pulled those up. So it was paid in 2010. Now, I think her 2010 taxes were paid in 2011, and that's when she went before the Board of Equalization on that. But, and I feel like I take some of the responsibility. Miss Lee came to me on numerous occasions, and I think I conveyed that to Mr. Thomas Allen, but, and she asked me for a refund. I've never had anybody since I've been in office to ask me for a tax refund. And I didn't know what to do. I didn't grant it. Of course, I can't grant a tax refund. Only you can do that, but I didn't know that at the time. And so I kind of kept referring her to other entities. And I know 3 such occasions she came to my office. The one that, and I couldn't find anything on my calendar. I went back to my calendar, put her name in. Nothing relating to this came up. But after she left the other day, I went back in, and I remember that on one such occasion that we did a partial payment agreement for her 2012 taxes, which she has been meeting her obligations. And that date was January the 16th, 2013. That's the only thing. I have nothing in writing from Miss Lee other than she verbally asked me. And I went to Miss Bevel with it, and the chief appraiser in the tax assessor's office. And she was the one who, you know, I went to her and said, I don't know what to do. I sent her over here to you, which Janice wasn't there that day. And she said, tell her that she's got to go before the commissioners. And so, you know, it's in your hands. I'm going to let Miss Lee present her evidence or what she's found. But, you know, I do feel like in the future I will refer them here originally rather than give people the runaround. But since then, we've had 2 or 3 people to come up and ask for refunds. So this has kind of become something, a standard now. It's kind of bad, but you know, I do take responsibility that she did come and ask, and I did, but I don't have it in writing, but she did verbally come and ask, and I didn't know where to send her. So.
And part of the process when she first came and talked to you, would she have been within the time frame?
Yeah, she would have been. The day she filled out this payment agreement, she would have been in the time frame. So that's the only thing. I had the dates, and that's what I was trying to go back and see, because what was asked me, do you have anything with dates on it? Well, this is the only thing I have with a date on it, and that was a payment agreement. And that was on one such occasion that she did come in and ask.
So by her way of thinking, by doing that payment agreement on that day, that could have been her way of requesting in writing a refund.
Well, it just verifies that she did ask within a time limit. You know, there again, it's a gray area, you know.
One of the question marks I think the attorney was bringing up was whether it's done verbally or in writing is according to the law, but then when she did a payment agreement according to the writing, that may add some benefit to that.
And that I don't know, because we're talking about 2 different years, so I don't know. I just feel like in the future, I've learned from this. I know now, go ahead and get something in writing and go on and know where you're supposed to send them. But I feel like had I sent her to the right place originally, this would have already been resolved. But I didn't, because I didn't know what to do. So I'll let you go ahead and speak.
When we,
From a legal standpoint.
There's a couple of things, additional facts you might want to know. Technically, the time to make a written request to the commissioners expire on April 2nd. As the tax commissioner indicated, Ms. Lee did ask her what the process was, and I guess at the time the tax commissioner didn't have an answer. But she did refer Ms. Lee, I think, over to the Board of Assessors, and the Board of Assessors actually took up the request, I believe, on April 4th, which was 2 days after the time to make the written request to the commissioners. And at that point, the minutes of the Board of Assessors meeting reflect that the Board of Assessors told Ms. Lee that the request had to come to the commissioners. Now, the statute does say that a request must be made within writing within 3 years, but it also contemplates that the county commissioners should have procedures in place to deal with refund requests, and Ms. Lee should have been able to find those procedures in the tax commissioner's office. And technically, this may not meet the strict requirements, but she did make an effort, and I think she submitted something in writing to the assessors.
Which would have had to have been submitted for them to take it up on April 4th, had to have been
For them
submitted
to
prior to
her
April
on
2nd.
April 4th, she must have made some kind of
Can I make one point about this date issue? This was a case that was filed in the Superior Court. And we did not know we had an issue about the taxes until we received the order from the attorney saying it had been finalized in the Superior Court. And that was on September the 14th of last year. We had no reason to be out appealing to everybody when we were waiting on that court action thing to be completed.
And when you say we, Ms. Lee, that's the no group, I mean, that was the whole group that the verdict came down that you're referring to?
It was the lead group, wasn't it?
It was the lead group,
Oh, yeah.
40 lots there.
Okay.
And that was filed in a petition to the Superior Court. And I gave you a timeline on that. We met with the, after we got that order, we met with the attorney to try to resolve the issue there because he had not put in the proper year, and he couldn't even find the file on it in his office.
But the point that helps your case, Ms. Lee, more importantly, is what Attorney Cotwell just brought out, and also Attorney Kessler, was that you got on the agenda for the assessment, and so therefore you must have had some kind of request in writing before you got on that agenda. And that would meet with the law and what we're able to do.
We
That's
followed
where I
the,
understand it.
we followed the course of appeal as the law provides to the Equalization Board, and then we filed in the Superior Court. Then we later met with the attorney and the chief appraiser and came to an agreement with them. But when the final document came out, the agreement was not, it was not consistent with the agreement. And that's when we started looking to see what we could do about it.
Be clear, this question is referring to the assessors that represents the board of assessors, to the attorney that represents the board of assessors. And I don't know what went on that proceeding, but I do know that it was an appeal filed from 2010 taxes. The circumstances we've already talked about are the only circumstances that I think might authorize any kind of exception to the requirement of a written request for refund. I'm not advising you can't, under the circumstances, I'm not advising you that the law prevents a refund. But I will tell you that if the board does approve this request, it would be my recommendation that you prepare a written policy on tax refund requests for adoption at your next regular meeting, so that we don't have any confusion on the part of the taxpayer who wants to make a refund request in the future.
I would agree with that. I would clear things up for the future.
I had the same situation happen with Henry Wilkins, so don't feel bad, Ms. McDaniel. The same situation happened with me, a different kind of property with the same sort of situation. I was told, once it was sent in, that was it, nothing you can do. But I appreciate you being honest with us about that. My personal opinion, the obligation was met by Ms. Lane. Sorry that it happened, I'm sorry that we were in the situation sorry that y'all had the problems you had with subdivision value.
Got heard enough, I'll entertain a motion.
I'll make a motion that we approve the refund alternative number 1, tax year 2009, in the amount of $5,951.01.
Second.
Have a motion and a second, all in favor?
Aye.
Any opposed? So carried.
Thank you, folks. Appreciate your time and your effort.
Eric, can you, would you be the one to prepare that?
I think that the county has already done something that is probably about.
Good news. All right, we have a presentation, our 5:30 presentation, we run about 5:30.
Good afternoon. This is just the presentation of your second quarter retirement update for 457B, the 401A, and the defined benefit plan. This runs from January 1st, 2013 through June 30th of 2013. Your distributions were made to retirees in your 457B plan, as well as terminated participants in the amount of $111,122.79. Your contributions made by your active participants were in the amount of $214,272. Participants' overall investment is valued at $3,016,500, and the enrolled active participant rate is currently at 68.24%. For your 401A, again from January 1, 2013 to June 30th, 2013, your distributions were made to retirees and terminated participants in the amount of $85,257. Contributions by the county on behalf of the employees are $274.46. Value as of December 31st, 2012 was $3,779,836, with a value as of June 30th, 2013 of $4,309,520. You have a year-to-date return at a positive 10.19%. Your vested total value is $3,779,307. Participation rate is at 95.28%, and forfeitures currently sit at $55,726. For the defined benefit plan, as of December 31st, 2012, your investment portfolio was $6,381,080. The value of the investment portfolio as of June 30th, 2013 was $6,928,889. 6.54% is the current rate of return, and the 12-month rate of return is at positive 10.09. Of course, your defined benefit goal is to do a rate of return at 5% a year in order to meet your funding requirements on an actuary basis. To go over a little bit more of your asset allocations, your equities sit at $4,448,505. Your fixed income sits at $2,243,752, with the cash value being $228,631, and that's how we're coming up with the $6,928,889. If you look at the indices based upon their performance and our performance, the Dow is at a plus 15.20. The S&P total return is a plus 13.82. The EAFE is at a positive 4.47. The Barclays Government Intermediate is at a negative 1.45%, and the U.S. broad market is performing at a negative 2.46. At this point, you are still in the moderate investment objective. I have no changes recommended at this time. You will be looking at your investment policy a little bit later in the evening. And if you have any further questions, I do have LPL Financial on hand if you'd like to ask about specific funds at this time.
Questions from the board? Thank you for your presentation.
Absolutely. Thank you very much.
That's if everything ran out well. Maybe we should let y'all take over the water and sewer.
Can you take it?
I don't know. Steve?
All right, moving on to new business.
Debt.
Item number 1, consideration to approve an agreement between the Board of Commissioners and AMS for use and monitoring of a scram device. That is it.
Mr. Zittrow seems to be detained at the moment. This is a contract for $7,500 for an ankle monitoring agreement. It is for the complete units, and the offender will pay a rental fee to have the luxury of an ankle monitor versus the probation requirements. It is for 5 sets. This has been budgeted in the upcoming budget.
Still be paid by the offenders, that's right.
However, we have to, we're paid in arrears, so we pay out first, they pay us.
And I understand it's cheaper to do this than you will incarcerate.
That's correct. Yes.
Okay, that was something I wasn't clear on. You're saying that we are paid back.
That's correct, yes. And
$125, isn't it?
That's the incarceration.
What we get back.
I think it's $10 a day to come back.
The thing is, if I remember correctly, and I apologize, Mr. Citro, I was going to make this presentation. I believe that the total cost per day per unit is $6.70, and that the offender will pay somewhere north of $10. Is that correct?
If you look on page 7 of 7, the cost or on there, depends on if it's a bracelet setter or the base and bracelet. There's two fees, there's a rental fee, and then there's a daily monitoring fee. The daily monitoring fee is $6.70. The offender will pay $10 a day. The monthly rental fee is $70 a month for the complete set. And our initial contracts, we have to take 5 sets for 30 days. And after which time we can send them back and get 1 set per time, a minimum of 30 days.
Okay, so this should be a net zero cost to us in the long run, and then we're supposed to save money on jail costs. Should be a savings.
And that's what I'm trying to get to, is the user going to pay for these units?
It is my understanding that the user is to pay for these units. The reason why the $7,500 was put in there was so that if for some reason we had people who did not pay, okay, that we were covered on that cost within the budget.
Well, that's how what I was reading, and that was bothering me because I don't want them to not be able to pay. I want there to be a way they're able to not pay. So how would that work?
If they don't pay, they go to prison.
There's got to be a time limit. I mean, a
But
payment
still,
from however
some
many days.
collection, we don't just pay it. Just can't.
The technicality is there may be instances where they are not able to pay, but they are on that program. And as such, we may have to pay for those particular expenses of these ankle bracelets should they not be able to pay. And I think that's where...
But in truth, what we should have is, do we have, Joanne, excuse me, y'all. But in truth,
About the erosion, glad you got here.
since we're putting this charge in here and we're saying that on the prison side it's $25, on the side it's $10, we're going to say on prison, have we reduced some cost in the prison to offset this? Have we done that? Because that would seem to make sense.
I just not incorporate when there's a savings.
But in the budget, are we reflecting that so that,
At this particular time, no, because we're not sure exactly where this program's going to go, number one, and I don't know that that's applicable necessarily to these particular defenders.
in other words, to show the taxpayers, if we're going to spend $7,500 possibly for people that can't pay on this side, we're removing that from the budget on the jail side because we obviously know we're going to save it over there.
I'm assuming that you're going to put these on people that possibly go out and have a job that can pay it back.
Exactly. That's the whole goal, is to put them on someone, hold them accountable for their actions and drinking
Mr.
alcohol.
Zittrow, sorry, you need to state your name for the record.
Oh, David Zittrower, I'm sorry, I'm with the probation department. Excuse me. Where our goal would be to put them on offenders that can afford them, and that way they would not be incarcerated based on a second offense, DUI, or a drinking offense.
Well, is there a way to make them pay up front so that if they can't pay for it,
We could, the court could order that.
that would incentivize them?
Yes,
They
ma'am.
don't want to go to jail, right? So
Right.
that'd be the incentive right
Or a
there is pay
deposit
upfront.
of some sort.
Yeah,
Yes, we could.
I'd say let them.
That would something the court would have to order or decide.
So that's a good solution. Let them pay
That's
upfront.
what Judge Thompson can do then.
Yeah. Yes, sir.
What do you think of that?
I'm satisfied with that.
Yeah.
That's at his discretion, right?
That's correct. I don't think we
If
would
you
tell
want more units, if he doesn't.
But we could make a motion that we approve this project based on that that's a requirement.
I think the whole thing, David, is the fact that the board spending the money. They're looking how the money's coming back to where this is a zero cost to the county. Will that happen?
If the offender can afford to pay for it, yes. And I think if he selectively picks who he puts the devices on, then yes, the money would come back, and it may come back a little more. We may make a little money. I don't want to say make, but I think the final bottom line cost would be $760 a day,
670.
$670 a day, and then if we charge them $10 a day, then that could maybe fund us having some more bracelets coming in.
Well, it's just like setting up a bond for somebody, say they've got to pay up front, they want to get this provision and it's taken care of.
So the bottom line, this is basically to fund your program. The board will never get this 7,500 back, but it should be an ongoing income that will keep the program going. Is that?
I don't know that if it would get it back, but it may not even spend it if the offender can afford to pay for it.
Okay.
And we may not even come out of pocket with anything.
So basically, this is an authorization by this board, as I understand it, to spend up to this amount to get this program.
Yes, sir. That will, it gives us a little insurance in case we have an offender that cannot afford to pay for the bracelet.
So we can approve the program without approving the taxpayer's insurance and make the offender pay for it up front.
Mr. Chairman,
Yes, sir.
I would not recommend you put those kind of restrictions on the use of the ankle monitors.
I don't think that's going to happen.
In Georgia, you cannot segregate who you're going to send to prison versus who you're going to put on an ankle monitor based on their income. It's the United States Constitution does not allow it. If the judge thinks someone is otherwise eligible for the program, it needs to be left at his discretion to decide. Now, I'm certain Judge Thompson will exercise his discretion in this program for those who are the most likely to succeed. And I would think that those people most likely to succeed will be people who are employed and who are stable. So, but I think we need to leave it to his discretion. I would not recommend you put restrictions.
But isn't it the same thing when this board agrees to fund a prison out there? We're doing the same thing. We're making a facility available for the court system to put people into. And we're not giving any, we're not saying, okay, we're going to provide funding for this prison, but Judge, we expect you to send this many people out there in this manner.
I'm
This
just
is-
looking for a way that the taxpayers
So-
have to pay for.
So I think this board is considering this as a $7,500 funding of this program, never to possibly see it come back. I mean, it's basically to fund this program. And hopefully then it will.
I believe that where you're headed with this is this is seed money for a
This is-
program.
This is seed money that you're asking this
What we
board
need
to
to
give
consider
you to start a program that
Is it
hopefully is
worth,
going to be ongoing and grow from this seed money. But this board will never see this money back.
but what we need to consider is it worth the $7,500 to seed this program and then in the future, for $7 a day, we can not have somebody in jail.
What's our jail per day incarceration?
They've got a 25 here, but I think it's actually 35, isn't it? Isn't that what we're actually running around?
I put 25 on there because that's what I think we pay. The jail pays to house someone somewhere else. And
We
it's
we
probably-
pay anywhere from $25 to $35, depending upon where that is. It cost us, I believe the last time we figured that was about $42 a day to house it.
It should be a worthwhile project, without a question mark. It should act and save us money and keep people productive, that on minimal sense.
Yes, ma'am.
Should. But I think for this board to consider this funding, it is seed money for a program that if all of this money is expended, we will never see it again.
It's just that,
Yes.
how many people.
It could get there, yes.
That's all I'm trying to get across.
My question, did you say this not budget now?
It is a
It's already in the budget.
In the 2014 budget, it has been included.
In the proposal.
In the proposed budget, we still have to.
Vote on tonight, hopefully.
Okay. Any other questions?
All right, so one more thing to clarify. We're talking about buying these at $1,500 each. There will be no rental associated.
No, it's a rental. It's a rental. I think it's for the 6 months, if I'm not mistaken.
It's for a year.
It's for, it says a year. I'm sorry now.
Exhibit A, page 707, through the period ending June 30th, 2014.
Under number 3, pricing, that's where you look at, it starts out with purchase, then it goes down to rental. It's sort of under number 3, it's very bottom.
There's options here, but our proposal is to rent these.
Yes, sir.
The county cannot, there's also termination provision for non-appropriation funds, breach, or consent. So if both parties mutually agree not to continue the service, you could get out of contract.
Okay, so is purchasing good with finance good, everybody good with doing this, if this board agrees to do this? Because basically this is
I believe in speaking with David that they will have controls in place to ensure that there is adequate review and monitoring of the receipts that are coming in.
Yes.
And also to the fact that the charges will be made timely. So with that in place through the probation office, I believe that we will, be able to ensure that it is a successful program.
There'll be a separate line item made for it, for whenever they make their payments, it will go directly back into that line item so we can track and see what's paid and what's not.
All right, so is there any kind of maintenance contracts or any, in this rental, any repairs and all is covered by this?
It's included bracelets, if we have to change it, something tears up, they have it all covered in there in the rental contract. Training, everything is covered in it. And just to add, it's not, it don't have to be solely for probation. It could be a condition that the sheriff uses for bond. When someone can't bond out, if they want to make, it's a multiple offender, and part of their bond, they can make wearing an ankle monitor, and we would just monitor it for them.
This is the first time we've done this in Effingham County?
Yes, sir.
Have you talked to other counties to see how it works with their offices?
Chatham County uses one, they use an independent contractor, and we've actually, as part of some of our orders, had to, let them come in and use it. We had an interstate compact case from Florida that, as part of their probation, the offender had to have one on. And we had to go to, we had to supervise him because he lived in this county. Well, he had to go to Savannah to get the monitor and wear it for 90 days, for 3 months, as part of his probation orders in Florida.
Any other questions? I'm going to take a motion to approve.
I make the motion that we approve the agreement.
Second.
Have a motion and a second. All in favor?
Aye.
Any opposed? So carried.
Thank you.
Thank you, sir.
I apologize for being late. I was at a conference in Savannah.
Sorry
Forgive me.
to give it to you just because you were late.
Well, luckily I didn't get speeding tickets, so I'm good.
All right, next item, consideration to approve an abatement of delinquent charges from EMS services for Dorothy Jackman.
Mr. Chairman, Ms. Dorothy Jackman is an 81-year-old disabled senior citizen on a fixed income. Ms. Jackman is requesting to be released the charges incurred on the September 14, 2012 services rendered by EMS. And you have her bill in the book. Our total charge is $81.97.
So this is charges after Social Security or Medicare or whatever you made their payments. Is there someone here to represent Ms. Jackman?
Ms. Jackman is not Ms. Jackman, yes.
Would you like to make a statement of any kind, ma'am?
Yes, the Medicare is paid, 300 and something.
Wait till you get up to that little microphone, please, ma'am, so we can hear you.
Okay.
Thank you.
Medicare paid 300 and something of the $400 bill, and that's the balance. And I think you also have a copy of my monthly income, so it's just a little difficult. I live alone. I had to call 911 when I was in cardiac arrest. And when you call 911, they send out the EMTs, so you don't really have a choice of, whatever.
Were they willing, which I understand your situation with the monthly income, were they willing to do any kind of payment schedule for you?
I'm sure they would, sir. But it's still hard with my monthly income.
So you've not talked to them about a payment schedule, or they have not offered you one to this day?
No, they have not yet, but I'm
And it's my understanding that if you were to pay them $2-3 a month, then they will take those payments until whenever.
Minimum's $5.
$5.
Yes, sir.
I'm learning just like the tax commissioner.
I would say the hard problem for us would be that probably a high percentage of people that call emergency EMS are older people on fixed incomes that need immediate emergency, and they're in your same situation. So if we were to decide to just do away with the fee, how would we not do that for all of those in that situation? I can certainly sympathize with you as a father if you're the same age and situation. So, but I think that would be our problem in trying to do that. And if you were able to make payments of like $5 a month, I think that would be the best solution if that's a possibility.
Yes, it would have to be then. If I can't get it abated, I'll have to do it.
Any other question or statement from anyone?
Ms. Chapman, where do you live at? Which area?
I live in Springfield and the
So you live in...
Forest Hill subdivision,
Okay, and you were taken to Effingham or taken to Savannah?
Effingham.
Is it rather than, oh, there's $5 there, right there.
We had said $5 a person.
I'm sorry, Ms. Jagger, we just trying to figure out how much money to get from Mr. Mack.
Yeah, Mr. Thompson, it's a $5 penalty for
Oh,
selling.
all right.
Is an option for us to reduce the amount of the charge rather than leaving the debt? It seems a bit excessive for that trip, but, and I'm wishing that someone's going to set a precedent. This is hard on me right here.
3.4 miles.
We don't know what was administered when you're in there.
I know. Well, while I can certainly sympathize, I don't have a vote. I don't know how you can just do away with the charges. I do believe that the work with a payment. This is a common situation. So if there's no other questions, I'll entertain a motion. This is a tough one, don't everybody speak up at one time.
Make a motion that we deny the request.
I have a motion and a second. All in favor? Any opposed? Ms. Jackman, we
Thank
have
you.
denied your request, and what I would ask is that you contact them and get this set up on a payment schedule.
Okay.
Okay?
Thank you, sir.
Thank you.
Sorry, we need to do more.
Well, it's tough when you got one population that you couldn't have to treat everybody the same. You again.
Sorry. Sit back on.
You again. Go ahead, Steve. Your turn. Consideration to amend the water and sewer agreement from Blandford Crossing.
Thank you, Mr. Chairman. The next four items are essentially similar. These all derive from the board's desire to cease collecting impact fees and to start collecting another type of capital cost recovery fee in its place. Staff's review and the attorney's review of the situation when it comes to stopping the collection of impact fees and starting the collection of a different capital cost recovery fee basically showed that we have several water and sewer agreements still out there that have reimbursement schedules, and those reimbursement schedules specifically refer to impact fees in the text of the agreement. So the
issue there being that this agreement specifically calls out impact fees, but if we're no longer collecting impact fees, do we still have the reimbursement responsibility? If it's the board's desire to continue reimbursing these entities during the, via the water and sewer agreements, then they're going to have to be amended to basically say whatever name we give in the capital cost recovery fees instead of saying simply impact fees. So these four items are prefaced by that particular thing. With the first one, Blandford Crossing is slightly more complicated than the others. Blandford Crossing has never actually been assigned to the current owner of the subdivision. The owner of the subdivision purchased the subdivision from a bank that had been closed by, that had received the assets from a closed bank, an FDIC closed bank. Therefore, the agreement was never transferred from the original, well, let's not even say the original because it was transferred from the original to a bank and not from the bank to the current developer. This agreement contemplates not only the change from impact fees to capital cost recovery fees, but also the assignment of the agreement from the existing Terra LLC and Atlantic Southern Bank over to the current owner of the development, Greenland Developers. And you'll notice that the last page of this particular agreement has signature blocks for consented to by Service Bank, which is the, in essence, the heir, or if you want to call it that, of the assets of Atlantic Southern Bank and also of Terra LLC. So Greenland Developers will have to seek and obtain the signatures of those folks consenting to the assignment of this agreement to them, and basically relieving the county of any sort of liability to those previous entities that have an existing agreement with the county as of this date. I think I'm going to stop and ask, does anybody have any questions or any concerns about what we're talking about here in general before we get too much farther into this?
Because the board actually reassigned this to Atlantic Southern, and then it was never, after the FDIC seized Atlantic Southern, it was never actually transferred to Service, correct?
Just to clarify, the agreements do require the approval of the assignment by the county. We don't actually assign it, we approve the assignment, yes sir. It was assigned from the original developer to two entities, Terra LLC and Atlantic Southern Bank, but it was never transferred to Certus Bank, although obviously it wouldn't because that was an FDIC transfer, and then it was never transferred to our knowledge. It's certainly not approved by the county in any way over to Certus Bank.
And this agreement still has the same reimbursement schedule and everything as the original?
Right, there's no, this amendment has no change whatsoever to the amounts of the reimbursement or the schedule of said reimbursements. It has nothing to do with that, just simply changing the entity that gets paid by the assignment, and then the wording of which fees we're going to collect and which fees we're going to reimburse to them.
And we're getting everybody in the middle to sign off and say that this board is waived of any liability.
It would be
doing so.
It would be the responsibility of Greenland Developers to obtain those signatures, not the county, but yes, those signatures should be obtained.
Would that be obtained before any disbursements from the county was to be made to Greenland under this agreement?
Absolutely. I mean, we have no agreement with Greenland as of today. So yes, it would have to be amended by the county and approved and signed before we would make any sort of reimbursements to Greenland. Now, that being said, no houses have been built in Greenland and no building permits are currently pending in Greenland. In Blandford Crossing, sorry.
There's none pending?
Not as of today, no, sir. No building permits have been issued, so no fees have been paid.
Okay, all right.
I understand they want to build some houses in there, but there's an issue with the lift station that's completely unrelated to this agreement amendment.
So from a legal standpoint, we're good with it.
I have a couple of questions. One thing I want to state up front is, Steve mentioned the next four items, but we're not handling them in block because they all are individually different.
They're all
I want to clarify that because the fourth item is a contract that would cover Steve Jones Construction, and I need to recuse myself from that when we get to that. So I just want to be clear that these are not all the same.
They are not all the same.
They're not identical.
Similar, and the intention in drafting these was similar, which was to try to get all of them in front of you at the same time and to craft an amendment to the existing agreements to treat all of the developers who are entitled to reimbursement the same way. The wording is different just because there were some different unique circumstances. And for example, the Exley tract property in New Savannah was different because they made a cash payment to the county as opposed to building infrastructure. There are other differences, but that one, is sort of one that jumps out.
I do have an additional question that it won't cover this first item completely because it does have a separate issue of reassigning it, but it's just as far as covering the issue of us changing from impact fees to capital cost recovery or whatever. Do we not take care of our issue if we just address that in the ordinance and say that in the ordinance, anyone that has outstanding impact fee contract money due will be either paid through impact fee or capital cost recovery? Because I believe there may be some people that are missing from here tonight, so if we do a few contracts and then we change the ordinance and there's some people we didn't address, that's not real.
Well, we catch the ones that we can, and then we do the catch-all for those that we can't.
But wouldn't we cover it if we added it to the ordinance?
The problem, I like the way you're thinking. The problem, as I see it, is that ordinances can be changed by future boards.
Mm-hmm.
So you can put that in the ordinance now, the future board can come in and say,
That's what every
we don't agree
ordinance,
with
that's what every ordinance we create.
So if you amend the agreement to say that whether we have impact fees, capital cost recovery fees, aid to construction fees, or any fees that are designed to recover capital costs by whatever name, the county will continue to pay you. Then the other party to the agreement actually has an enforceable right that that a future board couldn't defeat by coming in and changing the ordinance. So that would be-
Can you amend expired agreements? There's a whole bunch of situations with these agreements, and they're all different. They have different expiration dates and things like that, and some of them I know are expired, and there's a few other issues involved with them. And I'm all in favor of changing the ordinance and moving forward because we need to do that in order to comply with the law, period. But that's why I was wondering about some of the different wording of some of these.
And we may need to, we'll try to put these together at conference meeting. And the intention was to send a letter to each developer with their proposed amendment agreement. We need to revisit them, it'll take another 2 weeks until the 6th to address some of those questions.
I think there's some issues with some of them that we need to address.
Well, this was designed to start the process and dialogue that's going on now, to see if this is even how the board wants to address this issue. And I think there's a couple of questions. One, do we want to get rid of impact fees, which I believe we do, and if so, we need to handle these in some manner, whether it's this or another one. And there's also an amendment to the impact fee ordinance on this particular agenda. That being an ordinance that requires 2 readings, certainly you can't settle that night. We certainly wouldn't ask the board to have the second reading until such time all these ordinances are approved also. So, also there's some time that the study has to be amended. Those things have to happen. But more than anything, we really want to start this dialogue, to see how the board want to move forward with this.
So are you saying that we could table contracts till the next meeting and then move forward to the item about changing the ordinance? And we could have a first reading of that tonight?
You could have the first reading tonight.
That's a possibility.
Yeah. We just want to kind of get these in front of you to give you an idea of the framework or at least a proposal. It's one way of going about it.
Understand.
And if there's specific concerns the board has, certainly we can take those back and address them in the meantime, between now and the next meeting.
Well, I was out of town on vacation and wasn't able to get my book until yesterday. And so when I saw the contracts, I had some, but I didn't think I had enough time to get this problem addressed.
385 pages.
Sorry.
So,
Well, certainly, even if the board approved these all informed tonight, we still have to get with the other party and have their signatures too, so there's nothing saying that will be done on the next meeting either.
I mean, table because there's issues with each one of them.
Yes, ma'am, I'm just saying that even if we act on it tonight, doesn't mean this issue will go away at the next meeting, so it's still going to be the beginning of the process.
Well, if this is meant to be a dialogue, then what's the
Yeah.
issue specifically with this person?
Well, I haven't studied in detail for this meeting. I've studied most of the water and sewer agreements in detail in the past, but I haven't studied for this meeting about the expiration dates, and I know some of them have expired, and I don't know how you can amend an expired contract. That was one of the biggest ones.
I think if both parties agree to it, I think if we agree to it and they agree to it,
I think you have to have a new contract. I don't think you can amend an existing, but I'm not an attorney. I just think I have extra time.
I have to look, I don't recall it, I don't recall it being expired, that doesn't mean not. The reimbursement agreements, I would have thought were not expired, but we'll double check.
Well, this one here would be hard to just say if you call it a new agreement, it can still get everybody to sign off and state this old agreement existed and you're acknowledging that.
Later, that.
There are other issues that I think could probably be discussed in executive session and possible affecting litigation, but.
Well, correct me if I mean, they're waiting on this to start homes, correct? This particular one.
No.
The one, Blanford?
Again, the construction of houses in Blanford Crossing is nothing to do with this agreement directly. Now, granted, they won't get reimbursed from any construction that may take place in Blanford Crossing without this agreement going forward, but that's not stopping them from building any houses.
Okay, because I thought, prior meeting, you let us, somebody, maybe not you, said you need to be aware that there are wanting to start houses and
Yes, sir.
lift station is not available.
That's the lift station, and again, that's not a subject of this contract. The lift station is a completely separate topic from this agreement. It has nothing to do with this.
It wasn't a reimbursement issue, Mr. Chairman, that was an issue of it being not operable.
Right,
But it was not, the actual physical infrastructure had not been completed.
correct.
that we're letting them start building the house, knowing that the lift station is not operating.
Right, but the lift station is not a subject of this agreement, nor is it even relevant at all. Right, I mean, this contract is not an impediment to them, this amendment is not an impediment to them building houses.
Okay. Well, I have an agenda that has these items on it. Is it the wishes of the board to table items number 3, 4, 5, 6, and 7 on this agenda?
Well, I think we need to get these things wrapped up, but in my opinion, if any of us don't feel comfortable discussing something because they hadn't had a chance to read through it, I'm okay with tabling it. I mean, many of these things we've been talking about for a long time.
Just keep in mind that the next meeting is 2 weeks from today, and the deadline for getting things on the next agenda, if we're tabling it to the next agenda, would be Thursday. Of course, we can still submit some items after Thursday, but we're going to have to know what issues the board has with these contracts so that we can try to get them addressed.
I can be part of the motion where we table 3, 4, and 5, and I need to repeat myself for 6, and I think we can still discuss 7.
Yeah, 7 certainly.
Okay.
I think Steve answered the question. In my opinion, the way I would see that happening is you've already submitted everything.
Yes.
And so you've met the deadline for getting it on the next agenda.
Well, sure, yes.
And any questions that any commissioner has, email them for answers, and then we'll discuss.
I mean,
it next meeting.
right, we can't get them addressed if we don't know what they are, right? I mean, if it's just expiration date and that's it, we'll certainly go fetch the expiration dates for all of these, that's no problem.
The deadline, you don't have to answer the question before to get it on the next agenda.
Right, we just need to know what the questions are so that we can be prepared to answer them at the next meeting, yes, sir.
Right.
That's what I was getting
And
at.
just send those out before the next meeting, the questions and answers, okay?
Once we get some
And I'll make a motion, we table, items 3, 4, 5, and 6.
I need to recuse myself for 6. Can we do that separate?
Well, I think we're just gonna table, see where that's at.
It's
Is it conflict?
Let me recuse
All
myself.
right, the motion is to table items 3, 4, and 5 to the next meeting.
I'll second.
Have a motion and a second to table items 3, 4, and 5 to our next meeting, which is, what is that? 6th.
Are you doing a day specific, or are you just gonna do it to the next meeting, so we don't run into that date?
I know to August 6th, let me clarify that, to the next scheduled meeting, not a special call meeting, the next scheduled meeting.
August 6th.
Yes.
Item 3,
My second thing,
4,
And
and
5.
5. Have a motion and a second, all in favor?
Aye.
Any opposed? So carried. Item number 6, then.
Jones is confused.
Ms. Jones is recusing herself because of personal conflict.
I'll make a motion again that we table this to the August 6th meeting.
All right, let the record show, we still have 4 as a quorum. We have 3 voting, so we can still transact business. Motion and a second. All in favor?
Aye.
Any opposed? So tabled. Item number 7, consideration to amend the development impact fee ordinance of Effingham County. We will now discuss.
Basically what I said before, there's a proposed ordinance amendment that would remove water and sewer impact fees from collection. Of course, they would be immediately replaced by the existing fees in the existing utility ordinance sections 75203A and 75202A, water connection service charge and sewer development fee respectively. Those fees are identical in amounts to the impact fees. So nothing will functionally change when someone comes in for a building permit. They would pay the same fee. Just go into a different account.
Eric, would we be legally safe to go ahead and change this ordinance without addressing the agreements, in your opinion?
I think you approve the first reading because it does take 2 readings. Your action won't be final until the second reading is approved.
Which we won't do until the agreements are modified.
But if it is the board's will, we will certainly stop collecting impact fees tomorrow and start collecting capital cost recovery fees, quote unquote, tomorrow. So that the amount will continue to go into that account.
Well,
You would do that until after the second reading.
The second reading.
We could do it, but either way, I mean, those fees are already existing. And there's existing ordinance that allows for the collection of impact fees and an existing ordinance that allows for the collection of utility connection fees. So we can swap from one to the other at any time, as long as the board agrees to it one way or the other.
The benefit of doing so is we have to expend the funds that are currently in that account prior to disposition of the ordinance, if you will. So, and Eric may want
Oh, I see what you're saying.
to have some comment on that. If there's existing funds in the account that have been collected as impact, I don't know if we can technically do away with the ordinance that allows us to collect those funds and distribute them.
Certainly not the second reading of the ordinance, right? We could do a first reading and we could go ahead and stop collecting those impact fees so that they don't continue to pile up. I mean, otherwise we'll never be able to actually dispense with the ordinance because we'll never actually stop collecting them.
but the cost recovery, if that's what we're going to call it, ordinance does not exist until after the second reading.
You know,
Oh, it exists now.
There is an existing ordinance.
It's
in
existing,
place.
right. It requires no modification of the ordinance for
And
you
so
to,
we're approving using that ordinance now. That ordinance has always been in place, and they've used it for certain particular water items.
those things that don't, to answer your question, those things that aren't applicable to impact fees, like existing buildings.
And so then we can just start collecting it over there because the ordinance has always been in place. And then we won't continue adding funds to the account, which we have to figure out where it's going.
Right.
It's not a new ordinance.
Correct, it is not a new ordinance, and it's an existing ordinance that already is in place and is being used, but only in certain situations. If the board would like, we can start using it in all situations.
And the fees are exactly.
And the fees are identical, right.
It was always that simple.
And the intention of this, to clarify for some of those who haven't been following through this, the way I see it, the intention of this, it's not so much for the monetary, because money's going to stay the same basically. It has to do with a lot of our reporting, the way that we're required to report.
Yes,
If that's the board's will, yes.
Legal compliance.
yes.
Clarify a lot of that.
Still won't cost everybody the same.
Correct. And again, the reason for trying to do away with water and sewer fees ahead of the remainder is we need to liberate the funds that are in public safety, recreation, and roads still and to do so requires an amendment to the study. This just allows these two particular funds to not be updated with the study.
So we're no longer collecting them.
Eric, is there any reason for us not to? I've got to admit, I'm a little bit confused, because it says our alternatives approve the revised ordinance or do nothing. If we already have an ordinance in place,
The revised ordinance that you're being asked to have a first reading for is the modification to the impact fee ordinance. Amendment to Appendix D of the Code of Effingham County.
okay.
That's what you're changing. You're not changing anything in relation to the Utility Ordinance, Chapter 75. That's staying the same.
Change the developmental impact fee act, I will have a first vote on that, but he's telling me, we already have a different ordinance in place that we can start using. We just
Continue.
have a different one in place already, but we could have always been using.
They should default to that immediately upon approval of this, right?
Well, certainly, yes, sir. I mean, once you've done the second reading on this, of course, right, there's only one ordinance that requires a fee collection, right? You're absolutely correct. Right. But we can go ahead and do that with the board's approval of the first reading to just go ahead and stop collecting the impact fees.
This is way too simple.
Really is.
Always was.
Try to make it simple, but
All right,
it works out that way.
well, I'm not beat it to death then. I have a motion.
I make a motion to approve the revised ordinance as presented.
I'll second.
I have a motion and a second. All in favor?
Aye.
Any opposed? Look there, you got one out of, 6.
I'm batting 200, yes, sir. Thank you.
Keep it up. All right, consideration to adopt an ADA transition plan and execute ADA self-evaluation for year 2013.
Title II of the Americans with Disabilities Act of 1990, the Code of Federal Regulations, and Section 504 of the Rehabilitation Act of 1973 require that the governments create and maintain an ADA transition plan. These regulations stipulate that the county must comply with provisions of the ADA and that the county cannot discriminate against persons with disabilities. If the county does not have an ADA transition plan, eligibility for federal funding could be in jeopardy. Georgia Department of Transportation, which serves as a pass-through for federal funding for road projects, is requesting a copy of the county's ADA transition plan to maintain eligibility for federal funding. The department is also requesting the execution of the ADA self-evaluation for year 2013 document, which is included on page 22 of your material. This transition plan sets in place a mechanism for self-evaluation of the county's facilities, programs, and services. Creates an action plan which states that the county will be, what the county will be doing to address ADA issues raised through self-evaluations, including completion dates and responsible party. It also establishes an ADA grievance policy. It establishes a reasonable modification policy and includes a self-evaluation for facility and sidewalks. In addition to these two, we just touched on this about the action plan. And the action plan does create some new duties and requirements for several county staff and departments, such as the research into devices to assist with hearing impaired in public meetings and website accessibility, designation of an ADA coordinator with training for the coordinator in all departments, and staff recommendation is to designate the human resource director as the ADA coordinator. Creation and consideration of a ADA work program which identifies the deficiencies in accessibility, compliance, cost of correction, and timeline for completion. Posting, advertising, educating citizens and staff, and including the ADA transition plan with reference there too in all of our county legal documents, as well as contracts and requests for proposals. Based on the action plan before you, several items will start immediately or have already been done or completed that will be done in this calendar year and ongoing. It is the intent and requirement of the plan that it is an evolving document which will be updated and show the county's commitment to continually examine our accessibility programs, facilities, and services. In an effort to seek public input on the creation of this plan, the county advertised the creation and location of the plan in both local newspapers seeking input and comments. The county also directed to send a draft plan to several individuals or organizations which represent or work with persons with disabilities. Staff recommends approval and adoption of the ADA transition plan, the execution of the ADA self-evaluation for year 2013, and the approval of this plan will also approve, just so for your clarification, will also approve the grievance policy and reasonable modification policy, which are included as part of the plan. We'd also recommend that you designate the human resource director as the ADA coordinator, although that's not required to do so.
Ms. Rush,
Yes.
are you getting another job? You okay with that?
Yes, it's fine.
Is there anything out there that would keep the county from executing this plan or going forward?
No, sir. I did receive some comments. One was in reference to an actual program research that was lacking in the county, and I noted that that person's issue should be addressed through item number 16, which is create a comprehensive programmatic self-assessment. This is typically a 40 to 50 page document that takes a department through every action that they have, is every service that they have from the time they enter the building to the time they leave the building. The second comment was that items number 9, 10, and 11 are so rudimentary that they probably shouldn't be included on the transition plan. They should be done immediately. We included those because we don't have that to present to you today.
And that'll help me see the agenda.
And several things, several of the recommendations that we found in researching this is putting the minutes, the agendas in Adobe so that somebody that opens up at home can increase the magnification and get larger print size. We can print large print copies of the agenda. We can put signage out front that says large print agendas available to help with those different types of things that we can do almost immediately.
So we're in violation right now. Our deadline was June 30th.
Actually, that was a typo by the Department of Transportation by email. It's actually July 13th.
Good.
They also sent it to the wrong chairman name, so
That's right.
they just didn't receive it.
All right, any questions?
So this doesn't, this stays with county-owned public facility, right? It's not, doesn't create a czar that's gonna go out into the private.
And
Thanks, sir.
but it does touch local governments and instrumentalities of government. So if it is a quasi-government, if it's held at our facility, those types of things, we fund them, we wouldn't have to touch those.
Well, we're not gonna go to Joe's Transmission that's been there for 50 years and.
But it will affect new construction stuff.
That's correct.
Any new construction will have to comply.
As it should, does anyway.
And there are basic provisions that buildings that are not newly constructed must comply.
Well, now the transition plan is how we get our non-existing buildings to existing. So yeah, any new construction is already required under Title II to provide certain design requirements.
So we have to put no there.
No, sir. It'll fall under reasonable modification.
Any questions? Entertain a motion. Everybody speak up for
Alternative one. Make a motion approved, alternate number 1.
have a motion and a second. All in favor?
Aye.
Any opposed? You get it, Stephanie? So carried. Consideration of approved farmer plan agreement to retain service for employee benefit plans. Ms. Rush, you're up again.
Rush Shedzinski, Human Resources Director. Just to give you some background on this, on January 25th of 2010, the Board of Commissioners did approve an agreement and letter of engagement with Hunter McLean as special counsel on various specific matters, including the Effingham County's retirement plan as they relate to the county employees. The purpose of this agreement and letter of engagement is to expand the scope of that engagement to include assisting the county with employee benefit plans in general and to clarify certain aspects of Hunter McLean's existing limited scope with the county and to update and restate the terms of the existing engagement. This will include the scope, the fees, work assignment, disbursement of the account, payment terms, and special counsel. The reason we are wanting to expand it is that due to the liability based in the healthcare reform and the Patient Protection Act, we will need counsel for that to make sure that our plans comply with any federal mandate. We ask that you approve the agreement for the retention of services with Hunter McLean. Eric Gobbold has reviewed the agreement and has asked for you to approve it as well.
Is this something that was already in place?
Yes, we have an agreement already with them, but the scope only included the retirement plans, and we are asking it to include the benefit plans as well. So that's the medical and the healthcare.
We've used them in the past for ERISA issues with the retirement plan because the lawyers that do ERISA work is highly specialized and it's very difficult to keep up with the changing regulations. The Healthcare Act has spawned a similar amount of regulation. In fact, the IRS is issuing most of the regulations that relate to the Healthcare Act, and they are issuing a set of regulations, and a few weeks later they're issuing contradictory regulations reversing their previous decisions, and it is something that really requires someone who is closely watching those regulations, and lawyers who do this are pretty much specialists in it.
Hunter McLean also have the attorneys that ACCG use to defend us as well, correct?
No.
No,
No, that's all of it.
that's all of them.
They've actually assisted.
They have assisted on
Okay.
that case.
I just wondered.
They have assisted on that case.
Any other questions?
What's the term? Is it a 1 year? Is it a term?
There isn't a, go ahead, Eric.
It's an at-will agreement.
Council at any time?
Yes. We will do a lot of the work for healthcare and retirement as we do in-house normally, but this is for anything that's specialized come up or anything that we would be under litigation for, or we do have a question as to your liability when you're signing off on a contract or anything coming forward.
Georgia Municipal Association actually has law firms, sort of, I guess, I won't say they're on retainer, but by agreement, they have law firms that really represent cities and counties in employment matters and are kind of available on call. You can bill, but it's probably a better rate because of their agreements with GMA. This is something we may want to take up with ACCG to determine if they have any plans in the future to have a law firm or several law firms that counties can go to on these types of issues without, use our collective buying power as through ACCG.
So this is like a service agreement with like an engineering firm in which it doesn't have to be renewed every year, correct?
And you can call on them when you want or not.
Any other questions? Entertain a motion.
Make a motion to approve the agreement for retention of services with Hunter McLean for employee benefit services.
I'll second.
Motion and a second, all in favor?
Aye.
Any opposed? So approved. Next item, benefit changes. Consideration to approve the defined benefit plan investment policy.
As a follow-up to our workshop on July 8th, we have updated and revised the investment policy. It is you have a copy of that. I do have LPL on hand. Ms. Jenny Nichols is here to go through your specific questions and to highlight those changes and see if we can get an approved agreement tonight to update the investment policy for the board. So I'm going to turn it over to her right now.
You're becoming a regular now, aren't you?
Yeah, you just can't get rid of me.
There you go, as long as you make enough money, you're.
I'm doing my best. I'm doing my best.
That's right.
Jenny Nichols from LPL, from Financial for the record. With your investment policy statement that we reviewed on July 8th, there was a few just updates. It really wasn't majorly amended, but we did have a few discussion points that we just need to do on an annual basis. On page 3 of 9, if you'll go to that page, we updated your IRS tax identification number because originally when this was written, it was not, you didn't have your own entity number, which you should have had at that time, but we did create it at the onset of the transition. That happened many years ago, but it was never updated. So now it is, and you have your own entity number there listed in the history of the plan. If you go on down where it's indented, it shows the amendments and the updates. And we had to update this because originally we had, on the onset of the transition in the investment policy statement, you had $2,114,362 and had made annual contributions of between $600,000 and $900,000 a year. We amended that and because of our workshop and in your annual review, that as of 2013, with 347 full-time employees, you are projected with projected salaries of $12,971,200, that your annual contributions will now be $500,000 to $600,000 a year because of the change in the contribution levels. Which is great because we've done well, and that's important. And that your value has also increased as well. And you'll note that at the bottom, that the assets now show $6,986,102.05 as of July 8th. So those were the major changes. Plus, we also went through the contribution changes, where the county was making 5% contribution, and that was changed on August 21st, or accepted, and then went effective September 1st, 2012, to 3%, and that the employees were taken from a mandated 3% to 1%. And again, that's because of the promise that we've had in the liability, and you're in an overfunded status. Any questions with that? We good? We're good? Okay. Going on to page 6 of 9, the only other change that we made was actually your index for the growth and value large cap equity portion in the asset class index and peer comparisons. It was changed to Russell 1000 growth and Russell 1000 value to be accurate. And those are the only changes that we made. Everything else was deemed the same and ongoing.
On page 3 of 9.
Yes, ma'am.
I understand about those 3% or 5%, where that's corrected properly.
I'm sorry?
On page 3 of 9, I want to be sure that I was verifying that the 3% and 5% section is corrected properly.
I believe so.
I was reading that, I just want to be sure.
Yes, yours, the county contribution was changed from 5% to 3%, effective September 1, 2012, and the employees going on down further from 3% to 1% of their participant salary.
Okay. I see that. Thank you.
You're welcome. Questions? I have one other question for you guys. Did you happen to get this report with it, behind it? Chairman Kessler, you asked me for this and during our workshop. You did not? Okay. It was sent with this, but it is that report that I had promised I would give you. How do I get that to you guys?
Give it to the clerk and she can make copies.
Okay. All right. If you have any questions about that, the alpha, the beta, the standard deviation, everything is written down, and also the investment objectives for each particular fund so that you can review that at your leisure. Feel free to ask me any questions at any time.
Again, as long as you're doing a good job,
Well, thank you, Mr. Kessler.
we're happy.
If there's anything I can do for you, feel free to contact me. Okay, I'm done. Have a nice evening.
Any other questions, discussion on that? I'll entertain a motion.
Make a motion that the board adopt alternative number 1 for approval.
Motion and a second, all in favor? Any opposed? So carried. Thank you. Consideration to approve a resolution to set the 2013 sanitation fee rate. Sit down.
Yes, sir. I'm thinking that we may accidentally get through this piece before we get to the planning board.
Will the phone number?
Yes.
We can't hear what you say.
I'm sorry. I was looking at the time, and there's several things that we need to go through, both of these resolutions and also to the budget ordinance and budget approval.
We're contemplating doing sanitation and taking a break before that.
Sanitation, maybe,
The particular item that's before you right now is with the sanitation, and it is approving a resolution to set the 2013 sanitation fee rate. At this particular time, when we reviewed the funds that are received versus our actual expenditures, we felt as if the sanitation fees would remain the same for the current year. And so the resolution before you is to have the sanitation fee rate remain the same as 2012. And we simply ask for your approval of that resolution.
All right, I have before the board a resolution to keep the sanitation rates the same, no increase. Any questions? I'll entertain a motion. Anybody got anything to say about that? Keeping rates the same?
I'd like to speak something on it. On the sanitation, we come up here last year when they come out with the recycled, Stephen Thompson and commissioners, and I spoke on this thing about they come out with the recycling. The recycling was supposed to help cut down the fees of the trash and bring the price down. And at the same time, they come right back up and added $20 more onto the trash pickup because the sanitation was supposed to help cut down on the trash and bring the fees down. That last year, they added 20. And now y'all say you're trying to hold it the same. The recycling is not helping, and to bring the price down the way they ought to bring the fees back down. So we're going to just stay the same.
I'm thinking that without the recycling, we would be having to increase these rates. So yes, the recycling is helping to keep prices down.
Well, I tell you, I've had problems with both of them, the recycling and the trash, and my commission knows about it. And I think we need to look into some stuff there. And I constantly have to call them to pick it up, and I feel like we're not getting the service that we paid for.
Well, actually, to talk about that a little bit, since we don't have anybody here tonight for sanitation. The goal was, and what has happened is, because obviously when we started talking about recycling, I was probably the most skeptical commissioner here, because I just didn't really feel like people was going to join in on this. But we pay and you may still remember, I don't know if this was how trash was done back when you was on the board, but the way our contract is we pay for tonnage and we pay to run the route. So because of recycling, our cost of tonnage disposal has went down. So it has, actually correct. We have been able to not have an increase, and further than that, when our contract is coming back up with the disposal company, this is a bargaining chip with them to renegotiate our price with them. So hopefully we'll be able to maintain it. And fees are things that you don't necessarily see the change of the cost in your tax bill. Many times these things are absorbed by the digest, by the budget. That is how this program was originally put on. Originally it wasn't even covering the cost of it.
Correct.
So it is there. You can't see it on your, because it's listed as a fee, you can't see the change in it, but it is, I argue that there is a savings showing. And remember, I was the most skeptical of all.
Correct. And understanding it was supposed to be that when they picked up the recycle, they were supposed to get points and stuff like that. If you don't sign up, you don't get it the months that they pick time they come to pick yours up. If you don't call them, get your point, do this, you don't get it. I've got people that they've tried it, and they got so aggravated with it, they quit with it. They ain't done nothing with it. So that theory y'all put out to citizens, oh, y'all gonna get Walmart cards, y'all gonna get all this and that, that's clueless. Ain't nobody, they get so aggravated with it. You can't get on the porch, you sign up for it. Who gets it?
We had them on the carpet about that, and that's another thing that's going to be remembered when we renegotiate our contract.
Right, because see, some of them don't recycle. It's not right for me to recycle. He don't recycle, but yet he gets the same points, whatever. So I'm just looking at the point of view that the people, I think, was misled on this whole situation on the recycling. Don't get me wrong, the recycling's helping things, but I think the fees we was misled because it's supposed to be free, and the fees that same year they added a $20 to the trash. Still telling people the recycling was free, so there was still some increase. But now you're coming right back, and it was told at that time, yes, we're trying to get it down. The recycle would bring the trash pickup fees down. That's it. Thank you.
Jack Garvin from Clio. Folks, I'm going to tell you this. I used to give you a full green container of trash. Now I've cut it down to probably 1 or 2 bags. I think it's the best thing you ever did. I'm sorry about the cost, and I know you got some bugs to work out on it, but we'll leave it up to y'all to work those bugs out. But it's a great thing that you did with the recycling.
And there are some issues with the points.
That point says, you're right. We've had them here about it, and that I definitely intend on going through that next when we renew that. Because that is what was sold, Ms. Thompson was right. That is what was sold to me, and
The presentation to us.
exactly. And so whenever I relay that to folks in the public, I'm not being truthful with them in their eyes. So.
Anybody else?
Make a motion to approve the resolution to set the 2014 sanitation fee.
Second.
Motion and a second, all in favor? Any opposed? So carried. We're going to take a short break. We'll reconvene back here about 5 minutes after 7.
Mr. Chairman, before you stop, to clarify, on the agenda, we are setting the 2014 rate, right?
It's the title.
Yeah, on the agenda it says 2013.
Oh, yes, the resolution said 14.
Okay.
I'll catch that.
It's already been changed.
Yes, my notification, the agenda does say 13, but it is 14.
Reconvene at 7:05. Next item, consideration to approve the resolution to set the 2013 sanitation.
Mr.
We
Chairman.
need to go to the planning board, Mr. Chairman.
Oh, I'm sorry. I'm not really listening.
You get that line.
There you go, you give me enough time, I'll handle myself. It does have planning board. I think George is wanting to go home or something.
At some point.
All right, first item, the planning board recommends approving an application by Tim Wordite to rezone 5.18 acres located at 3165 Blue Jay Road from AR1 to I1, map 373-5, in the first district.
Where did I, oh yeah, he is here tonight, good. Would you like me to explain it, or would you like to?
Either one.
Okay. Well, they want to put in a surface mine. They're digging a pond for someone, but anything over an acre, the county considers a surface mine, as does the state. They have to go through that state mining application process, and we require them to rezone to industrial. Staff and planning board recommend approval with the stipulations.
Where in that track is the?
Let me show you right here. Let me see. Kind of the same way, yeah. Sorry, trying to get it lined up the same way. There we go.
Has Mr. Wordite seen the 7 stipulations? And
I don't know if you've seen a copy of this yet, but.
I have not.
Okay.
Did you go to the planning board?
It's, yeah.
No.
They're the same for pretty much all of our surface mining operations.
Yep.
That's probably fine. I'm in the middle of one right now, so.
There's nothing different on this particular site that we would do on other sites.
He's familiar with
Are there any homes nearby that's going to be impacted by this at all? With trucks coming and going, vibration?
No, sir, we use electric pumps, so it's quiet. The water, there's a watershed ditch that's right next to where we're gonna pump. It goes right out. The water's not gonna affect anybody. There's a home next door.
Nearest home is just south on.
Correct. Yeah. There's only
There's a
one.
couple across the street that may feel that, notice the truck traffic.
And it's gonna be during the day when they're at work. So.
How long does it, just out of curiosity, how long does it take to estimate? Just as same as needed?
Well, yes, sir. It depends on projects. I mean, we're digging a 22-acre pond now, and we've been doing it since 2008, and we're just about done. So.
That's a lake.
Anything over 11 acres is a lake, yes, sir.
Any questions? I'll entertain a motion.
I make a motion approval with the stipulation recommended by staff.
And I already messed up again. Is there anybody else here that has anything to say for or against this? Okay. And I got a motion to say. All in favor?
Now,
Sorry.
On the land is.
oh, okay, I see you waving your hand.
You're for it. Okay. Any opposed? So carried.
Thank you.
All right. Next item, planning board recommends approving an application by Lisa Sowell to rezone 3.50 acres located at 3917 Springfield Road from B2 and AR1 to AR2, map 260-1314, and being in the 3rd district.
Mr. Chairman, these folks had a shop in the back corner of the property, this B2 area, years ago. That is no longer in use. The remaining parcel is a non-conforming AR1 parcel. They want to reconfigure lot lines and rezone the entire piece, both parcels to AR2 to reconfigure some lot lines and change the layout. Planning board and staff will recommend approval, and the property owner is here to give questions.
Are you Ms. Sowell?
I'm Sandra Ewan. I own the property. Miss Sowers, my daughter, she's helping her with it. But we just
I presume you would like to have this done.
rezoned. Yes, please.
Anyone else here wish to speak for or against this? Board have any questions of this? I'll entertain a motion.
All right, I'll make a motion, we approve it with planning board and staff recommendation.
I'll second.
Motion and a second, all in favor?
Aye.
Any opposed? So carried.
Thank you.
You're welcome. Next item, planning board recommends approving an application by George Martin to rezone 1 acre located at 1358 Springfield Egypt Road from AR2 to AR1, map 341-16 in the 3rd district.
Gentlemen, Mr. Martin wishes to cut off a 1 acre parcel for to create a home site. I don't know if Mr. Martin's here tonight, but
George, remember?
It's more of a recombination, right?
It's a
Oh,
recombination. It's the housekeeping issue where they rezoned it back in the 80s
Okay.
for a home site.
Yeah.
It was never subdivided.
to re-lot back into the old lot. That's right.
Anyone here wish to speak for or against this? Any questions from the board? Entertain a motion.
I'll make a motion to approve with planning board and staff recommendation.
Second. I have a motion and 2 seconds. All in favor?
Aye.
Any opposed? So carried. Next item, the planning board recommends approving an application by Ronnie Brooks and Jimmy McDuffie, co-executives of the estate of Corey L. Lancaster, to rezone 10.26 acres located off of Springfield Egypt Road from AR1 to AR2, map 342-29, 3rd district.
Mr. Chairman, the bulk of this estate will go to Mr. Lancaster's son, but I believe there are 4 parcels that are going to other people other than his son, and they need to be rezoned to AR2. They're less than 5 acre parcels, and they are along Springfield Egypt Road. This skinny strip, going to make 3 parcels there, and just across the railroad tracks, we're going to take what was a 5 acre parcel, cut 1 acre out of it, and recombine the remaining with what's left, what's next door. And Mr. Brooks is here if you have any questions. Planning board and staff recommend approval.
How you doing, Mr. Ronnie?
Doing fine, thank you.
Good. What you got to say?
Well, basically, this was Mr. Lancaster's wishes. The people who are to receive this property are his grandchildren. And it was all in one tract originally. And this is the way he specified he wanted to divide it up. The bulk actually goes to his son, Richard. And then the other 4 parcels go to each one of his blood grandchildren. And there'll be no change of usage of the property. It's just a matter, because it was less than 5 acres, we had to have it rezoned.
Anybody here wishing to say anything for or against this? 3rd district, I'll entertain a motion.
Mr. Lawson, good friend, good fellow. I'll make a motion we approve this rezoning with planning board and staff recommendations.
I'll second.
Motion and a second, all in favor?
Aye.
Any opposed? So carried.
Thank you.
Next item, the planning board recommends approving a variance application by Diane Taylor to reduce the front setback to 25 feet located at 254 Church Road, map 366A-49, in the 3rd district.
Everything's going on up there guys.
I tell you, you're up there where it's happening.
Ms. Taylor had a mobile home brought onto this parcel, and got the application, and then had it brought in. When we went out to measure the pad, the setback did not meet the AR1 zoning. Now, this is a severely non-conforming lot, as are almost every lot on the street. The mobile home is laid out where a previous mobile home was, and almost every other home on the street has approximately the same setback. So it does not in any way look out of place or affect the visual aesthetics of the street. Staff and planning board recommend approval.
Anyone here wishing to speak for or against this?
You receive any written complaint, any written?
None whatsoever.
This is very much like the issue over in Melbourne, you know.
These are
community.
very tiny lots, and most of the homes are right up the road.
Sounds like it makes sense.
Entertain a motion?
Make a motion to approve the staff recommendation.
I'll second.
Motion and a second, all in favor?
Aye.
Any opposed? So carried. Next item, planning board recommends approving a variance application by Blaze. I'm bad with names.
No fee?
No fee? Y'all tell me if I get it wrong. To live in a recreational vehicle during the construction of his home located at 116 Runs Crossing Drive, map 407D-9 in the 3rd district.
Mr. Nofi has his home permitted and under construction. While staff is not able, due to the wording of the ordinance, to allow or to recommend approval, the planning board does recommend approval with a ending date, which is approximately when he believes he'll be done with his construction. And I'll let Mr. Nofi answer any questions he may have regarding the state of his construction.
Do we need to approve by September 4th? Is that when the,
Yes, sir. We just hit a little bit of a snag. We are still set to be done with construction by the end of August. I am working with the bank as of right now to go ahead and go from construction loan to a permanent loan, so I'm in the process of doing that. I think as soon as we get the CO, and then I think we can proceed on from there. I might need an extra week or two. I don't want to blindside you if we run into that little bit of a glitch, but I think we should be in pretty good shape. We are in state of all windows, doors. All the electrician was out there today, put the power panels on the outside of the house. I think we are due, I think Mr. Charlie Key has it set up for inspection for maybe tomorrow. I believe that'll be our final electrical inspection. Then we have to get plumbing and some other little minor things finished. So then we can start with the painting and the flooring. Cabinets are actually going to be delivered tomorrow. So we're trying to keep it on task as quick and as tight as we can. I just don't, just because of the weather a little bit, we ended up with a little bit of bump. We had a little leak in our roof, so we didn't want to drywall until that was fixed.
So if I understand you correctly, you would like maybe until September 30th, the end of September to be the end date?
That would be ideal if possible, but if not, I will take anything I could possibly get just to keep moving it forward. I hate just to run over a week.
So is it currently there and you guys are living in, or are you proposing to put it there?
No, sir. We did not know that that was not allowed. We are living in it right now. We are hooked up to the well and septic that we had installed. It's 2012 fifth wheel, so it's actually rather new.
Discovered by code enforcement.
Yes, sir.
We haven't had any other complaints about it.
this is what they
Was it by complaint or just?
It wasn't like complaint, I think.
It was discovered during construction, probably.
Yeah, right, he's in the process, that's what I'm saying, this was not like, we had a situation similar to that, not long ago, but the difference is, you're in the process, and you have an end date.
Yes, sir. We're about 60, probably to 70%, and that 65 to 70% finish range. With what my contractor gave me an estimate at.
Anyone else here wishes to speak for or against this? Once the house is constructed, I presume this same fifth wheel that you're living in is going to continue to be parked in that yard.
Yes, sir, it's going
Because
to,
that's your storage facility for your own fifth wheel.
yes, sir, it
So
will be.
the only difference is going to be that you're not going to be living in it.
Yes, sir.
It
It's
won't be
cool.
connected to the.
And it won't be connected.
Yes, sir, it's going to move from the side of the house back towards the property, back towards the pond.
And nobody from the public came and complained. It was codes this happened from this.
Our neighbors, we asked them before, and they said no, there was no issues.
No other questions on entertaining motion?
And obviously, we have two recommendations here. I think planning board is recommending approval, but staff recommendation is denial in that. And that is because there is an ordinance against living in one. But me personally, as long as no neighbors complaining and it's temporary for the construction of the house, I think it's very reasonable. And I'll make a motion that we approve this and give till September 30th.
Second.
We have a motion and a second. All in favor? Any opposed? You understand the approval, sir?
Yes, sir, thank you so very much, I do appreciate it. Thank you all.
Next item, planning board recommends approving a variance application by Jennifer Eisenhart to allow an RV trailer to be fully connected to electric, water, and sewer to allow for the care of cats located at 2630 Courthouse Road, map 345A-1 in the 4th district.
This item, the planning board actually recommends a partial disconnection of the water and the septic. This RV is being used for the housing of cats, and evidently not for people. So the planning board thought, well, we were told the cats needed air conditioning. So they were okay with electric being run, and I assume it's just an extension cord, but being run with the RV, but having it disconnected from the septic and water, so it is not really usable by humans.
Why did the cats need to separate?
That I advise them to answer this question.
The short of
State
it,
your name.
I'm sorry, Jennifer Eisenhart, I'm the owner of the property. I am not the owner of the RV in question. My roommate, Robert Mizell, is. The short answer is that the RV, Mr. Mizell, and the cats in question have been a resident at Whispering Pines for the last several years. I do not know how long. But in the last 4 years, Mr. Mizell has had cancer twice and has had to be moved out of his RV. And during that time, my family and I took care of him as well as the cats. And the cats are elderly. They are not litter box reliable. And he's had them since they were kittens. And the decision was made while he is currently healthy that my son left home, and I've got a 3-bedroom double wide on my property. So Mr. Mizell moved in with us, and we moved the trailer, the mobile home, the RV, I'm sorry. We moved the RV in, and we had a friend set up, who's an electrician, set up the electric and run the water so that we can, wash the cat bowls, and Mr. Mizell can sit and play with his cats. And one of the cats is diabetic and has to be fed 3 times a day and have insulin shots. And the idea is that it is a convenience for the life of the cats. With them not being, with their age and not being litter box reliable, I'm not real keen on them moving in with me. And at the same time, once you're in your 60s and you've had lung cancer and throat cancer, the odds of ending up needing additional care again are serious. We did not know that having it hooked up would be against the rules. I was told there was a complaint about the property in general, not just the RV. And we went to magistrate's court. Mr. Worth, Judge Sexton, Mr. Worth and I reached an agreement that we would have it, we would unplug it from the certified electrical outlet and run an extension cord until such time that we could come before the planning board. We came before the planning board, so we've plugged it back in, and now we're just waiting on the answer. I requested the sewer and water just to facilitate rinsing out the cat bowls, getting them fresh water, not lugging water, and because of the age of the RV, I didn't want the gray water going on the ground. But at this point, anything we get, we're going to be happy with.
So basically, you turned this RV into a kennel.
It's essentially a kennel, yes, sir.
And my opinion on this is, obviously, you can't live in an RV full time. You can, however, just like the fellow before you, when his house is completed, obviously he's going to have his RV at his house.
That's
And
correct.
obviously, everybody, all of us, including myself, that has an RV is going to keep it plugged up to maintain batteries and such as that. Now, I think that the electrical work, if the electrical work was inspected and it's up to code, you're good on the electrical, and I don't think it matters where you plug it in my opinion. The water and sewer connection, I think the answer there is you can't have it hooked up full time. But I think it's reasonable that you have a hose bib outside.
Okay.
But I think that the answer to your dilemma here is, obviously you're not trying to live in it.
No, sir.
And I think it's reasonable for it to be plugged up, and I think that's not against any ordinance that we have. So.
And if you leave cats in it.
That really doesn't, it could go into a health department issue, with how your property's kept, and if it's a health issue, but that's not what we're talking about.
It's saying that they're not litter body, litter box reliable, might be an issue.
Well, and this is one of the reasons why we were having everything hooked up, is because Mr. Mizell goes over at least 3 times a day. He cleans the litter box, he makes sure anything that needs washed is taken care of, and he gives the one cat his insulin shot, and visits his pets, but he resides in my house because obviously he can't live in the RV.
I guess my question is, why are we, if you can park an RV on your property and run a power cord out there to charge it, you need the door open?
The fully connected is the question that needs to
Right.
be
It's obvious you can't have water or sewer hooked up. Really,
But
you can have it, it's not illegal.
But your actual point is, it's not against the ordinance if she's not trying to live there and she's not.
That's right. I think you're within
She
compliance
wanted
as
to
long
have
as
water and
you're.
sewer connection.
Oh, I see what you're saying.
Right.
And it did.
Does the
As long
ordinance
as you
actually say, don't live there, or you can't have water and sewer connection? Because the way I read the ordinance, it says you can't live there.
Correct.
So it doesn't even address it.
Code enforcement can't tell the difference if it stays in active, so that's how we.
The ordinance doesn't even
I
address
got
it.
you. So to address that.
Actually, Mr. Worth came out and inspected it after we went to magistrate's court, and we were supposed to return to court. Mr. Worth contacted me and said that, based on his subsequent inspections, we did not have to return to court, and we had filed the variance request per the court request and Mr. Worth's request, and we've made efforts to make the RV less visible. The question was posed was why it's not in the backyard, but the backyard is right now under 6 inches of water, and I also don't have a drive to the backyard. So where it's parked is the only logical place.
Is there anyone else here that wishes to speak for or against this issue? So the reason these cats are in this RV rather than them moving into your home as well, as the gentleman has, is you would rather have them out there than in your home?
I would rather have them out there. They've been there their whole life. They're elderly. They moved in with their mother as newborn kittens. I have a younger cat in my house, and it just works out better for everybody.
All right. If this board tells her that she can take the sewage loose, and she can keep it hooked up to electric, then that's the way I understand the planning board is.
That was the planning board's recommendation. Remove the water and sewer
But
connection.
you know, there's something wrong with this picture if you can take that sewage line and dump gray water out on the road. I mean, out on the road.
If there's no water going to it, there's nothing coming out of it.
You said there could be a hose bib.
Outside, yeah, for watering for animals. It doesn't have to be connected to the camp. I don't think, I mean, honestly, I don't even know why we're even seeing this.
That's what I was, as we talked, that's what I was.
And that's what I was
This is
trying to
really
figure.
clear.
Anybody can have power to their RV.
I think the question is code enforcement seen it hooked up, completely hooked up, and makes a reasonable assumption there's somebody living there?
Correct.
That's reasonable.
All right.
So, but, and you understand that you cannot have anybody living in a camper full time.
Absolutely. And the purpose of even moving the camper was because if Mr. Mizell's not living in the camper, him paying Pete $300 a month to keep the camper parked at Whispering Pines when I've got 5 acres is silly, as well as my having to drive across county to take care of the cats, when I can walk out my front door and go do it.
It's almost a matter of, and I mean this well, denying the request for a variance and letting her have electric hooked up to it and.
Because it can't be just an extension cord to run your air conditioning. It's got to be electrical.
It can, you can't, if it's one air conditioner, it will run every floor. But, again, that's not our business. I mean, that's, I don't even know why we're seeing this. I think this could have been handled before it got to that point, but.
Well, so it's gone through the courts, it's gone through the planning board. This board needs to take action in some manner, am I correct?
We just need to know what we're providing variance from.
I guess the question is, should we approve or deny this, which is the.
Well, that's what I'm saying. It's accomplishing the same thing.
My preference, if I may, would be that you approve it with the understanding that the only living creatures in there, to my knowledge, will be the cats, on an overnight basis, that no one would live there.
So if it's power only, if we're not approving a variance, it's already allowed.
Yeah, I'm not.
I was told that was not allowed.
I wouldn't want to approve it for use for a kennel type thing. But I'm cool with just denying it and understanding that as far as I'm concerned, you're within the law.
Are we understanding correctly, for her to have power, she doesn't need a variance?
I'd be fine with that.
We're denying, if we deny the variance, then she would be mandated to remove the sewage hookup.
As myself and my code enforcement officer read the ordinance, it says it can't be used for living housekeeping purposes. With water and sewer, that's the appearance we have, and we have no way to tell otherwise. All those
I understand why it came up. That was pretty a reasonable assumption.
Yes.
But after court, Mr. Worth inspected it, and the sewer and water was unhooked, and I was still advised to go ahead with the variance request because of the electric, which is why I'm here and why I spent the $140 for the variance request.
I think what the variance request is for is to allow her to have water.
To rehook your water and sewer.
Does that make sense?
That's why I understand.
Yes. So if we deny
Any
the
and
variance,
all.
she still has power.
Okay.
Right. I think Phil's right. I think the answer here is to deny this, because this is to allow a full hookup for use for a, right?
If we deny the variance as requested, but everything that we've said here is on tape, and we're saying you can have power, that's already approved, period. And that's all you say, that you say you're okay with that. So we would be denying the water and sewer for the
Full
variance.
hookup.
And it'll be on record for the court or any code enforcement that we understand that there's power.
So we should make a motion to deny the variances submitted and to allow only electric hookup.
I don't think
I don't
we
think
need
we
to.
did that last time.
I think it is allowed. We don't need to stipulate that that's allowed.
We verbalized it, but we don't need to put that in motion.
I don't have one now, but I did, yes.
For conditioning purposes, you keep it plugged in for conditioning purposes.
Like I said, I was told at court we weren't allowed to do that.
And if you wouldn't have gone through court, and,
Did
you
they
know,
provide you
I would like to have
a-
some
The
clarification.
one that I applied for the variance, yes, ma'am.
It doesn't speak to it.
So, I guess we could create an RV policy.
So it sounds like this board needs to have an RV policy.
We do have. We do have.
We do have it, we just need to adjust it.
We do have.
With
It's
all
just
these,
the one, if you want to use one during your construction, I think it's best that they come to the board and apply for it, and so you can make sure, like the difference recently in the two cases we had, the one tonight and the one over in Melbourne, it was pretty apparent that you had one that was in construction, about to finish, and you had one that had no intention. Didn't appear to. So,
personally, I would like to deny her variance with the understanding of the board that under present policy, it's agreed, or whatever way that we feel that she's allowed to have electric only connected for condition. Something to give some type of clarification.
And I'm certainly fine with that.
Huh?
I was wrong, the board did not.
Well, can we do that?
You should need something to take back to magistrate too.
Well, that's what I'm saying. She needs something to go back to the court with this.
What I understand, she doesn't have to go back to the court. The judge instructed Mr. Worth to make sure everything's okay.
But rather than having to go through tapes and determine what this board is saying, I think it's easier for us to make a motion as to what our intent is and move forward.
With what you're saying, I'm sorry.
Okay.
It sounds like what you need is a motion to deny the variance and to direct the zoning administrator to send a letter to the applicant stating the board's current interpretation of its ordinance does not preclude connecting the RV with electrical connection.
I like that.
and further in the letter, that it is with the understanding this is not for a dwelling or full connection.
Human habitation.
Permanent habitation.
Which is different.
Wait, you'll have that for the code enforcement.
If somebody wants to give a motion that letter such as that be written, I would love that.
I'll make a motion, as Eric stated, do we need to restate it for the clerk? Please. Okay, we make a motion that we deny the variance request and we instruct the zoning department to send a letter stating that, what our, the board's current policy and understanding interpretation of is that she could be connected to power, and that is not used for any type of residential use.
Have a motion.
And obviously not full hookup.
Not full.
Okay. And I'll second that.
One second. All in favor?
Aye.
Any opposed? We'll go take everything loose and plug that.
So I will get a letter in the mail then
Yes.
to cover me. Thank you very much. Y'all have a good evening.
To clarify though, you had to run an extension cord and you couldn't hook up to some power that you had installed for it?
That is
I
correct.
want to clarify that, and, I mean,
I don't think we can
Power.
have the power plugged in.
no.
I mean,
I don't think
No.
I would care the source of
How,
power.
exactly, okay.
As long as
It's
it
not
meets- as long as it
habitable
meets-
without discharging water.
As long as it meets code, you know.
Yeah.
Okay.
thank you.
Thank you, ma'am.
Thank you.
Appreciate your time. Next item, planning board recommends approving an application fee to rezone 2 acres located at 2120 Courthouse Road from AR1 to AR2, map 370-7 in the 4th district.
McPhee intends to cut 2 acres off his 11-acre tract for a home site, and this is a rough sketch of how that would be laid out. And the planning board and staff recommend approval. 2-acre rezone.
Anyone here wish to speak for or against this? Any questions of staff? Do I have a motion?
What district is this?
4?
Make a motion to approve planning board recommendations.
I'll say.
Have a motion and a second to approve the rezoning with the planning board recommendations. All in favor? Any opposed? So carried. There's something about that thing with the lights. Get blind. The planning board recommends approving a zoning ordinance amendment to section 6.2.3, accessory structures of the Effingham County zoning ordinance.
Came up recently during a plans approval. Gentleman wanted to build a pole barn structure. And the inspector made note that it was over the 15 feet allowable for accessory structures. Well, when I found out about that, we realized that in AR1 especially, and even in AR2, many buildings are over 15 feet accessory structures. So we immediately went about amending the ordinance.
That was over my district right after I was elected.
Yes, exactly. And clearly this has been going on forever. Yes.
They're very confusing.
Yes. 35 feet was chosen as the allowable height of primary structure.
That has nothing to do
No
with
particular.
fire ratings or anything.
The 35 feet does have to do with fire rating, I believe. Chief still here, doesn't that? It does, yes.
Keeping it at, instead of going.
Yeah, reaching
Up to 30.
Okay. I want to be sure we wasn't doing anything that was going to be detrimental. Any questions? I'll entertain a motion.
I'll make a motion that we change this ordinance to allow for 35-foot in AR1 and AR2 districts.
I'll second.
I have a motion and a second. All in favor? Any opposed? So carried. The planning board recommends approving a zoning ordinance amendment to section 5.1.2, conditional uses in the AR-1 zoning district.
And you're familiar with this item. This was the gentleman that wants to have a solar array, solar farm. We did have to make an amendment to the ordinance to allow it as a conditional use in AR1 as opposed to having them rezone the property to industrial. And this is the draft amendment there, planning board. Staff recommended approval.
What have other counties done? There's other counties that have this solar farm.
From what I understand, they're going various ways. Some of them allow them just by right anywhere on agricultural land. Some of them are making changes or requiring them to rezone. Seen both.
And it's, the question I think,
They're income producing.
well, the question is, are you farming farming and harvesting the sun, or are you generating power? One would be agriculture, one would be industrial, you know? And from what, because I did a little research on it myself, I'm I agree with the harvesting, you know, that it does fall within the AR, you know?
Especially when they let the goats eat.
And I think some places are doing limits of acreage, so that it's not a, you know,
Massive.
a 300 or 400 acre site that is sure, you know, corporations doing.
Harvesting of the sun.
I know there's a new rule for solar arrays. I want to see the county miss out. How do you, I mean, it's an income producing business.
I would think that how the county's going to do anything with that is it's going to be an improvement on real property and the valuation.
Well, under staff recommendation, it says this is a way to add economic value to agricultural land. And in truth, if it is adding that economical value, then it should get reassessed in some way. It may not be a full.
I would assume so. I don't want to speak to the assessors, but I would assume that the value of the assessment is going to go up.
I'd like clarification on that.
I agree.
Before we move forward.
You know, the interesting item was, I think it was Steve that said something about this, if you had a house there, then you could build these solar panels on the roof, and nobody says anything about it. But if they're freestanding, then there's an issue.
Where I see a difference though is, they're using those solar power, those solar panels just for their home. This is to put acreage out there.
This is not necessary to a home. This is
Right, and that's the difference.
primary.
This is, and that is, I think that's the simplest way to put it is, are you harvesting, farming? And of course, if you did that, you're selling it, you know, whatever you harvest anyway off the land.
You go get a $250,000 metal building on a piece of property, you're reassessed. How do we capture that?
Well, I mean, I can check with the tax assessor. I would assume that they would certainly be reassessed. I mean, it's not just.
It would be, I'm sure,
empty land.
it would be a value put on
When
it.
anything's added like that, they're supposed to.
No, property could still be under the tax on the equipment. Yeah.
Say that, what you say.
They would be taxed on the equipment.
Right.
Like if they put freezers out there on the business, they tax those freezers. It'd be a personal property tax, is what you're saying.
And you got depreciation and everything else that falls in. So under this proposed amendment, this would be approved strictly within the judgment of the zoning administrator.
The purpose of that, if you remember the folks, was they were in a huge hurry and did not want to reapply for the conditional use. As soon as this is approved, they want me to say, go ahead and do it.
I understand the PSC just made a ruling 2 weeks ago that Georgia Power was required to add another, like 400 megawatts of solar power in the next few years. So if you don't get it this time, there's the other opportunity.
I don't doubt that. They were trying to get in on this first jump on this program, which came about really out of the blue. I mean, I heard about it the first time in maybe February, and they had to get started in March.
It's like a 2-week window to
It was
apply.
ridiculously short.
Does anybody here wish to speak to this item? Either for or against? Well, as for myself, I still have a problem with if I own a piece of property and someone owns a piece of property next to me, and they can just simply go out there and build solar panels on the property next to me, and I want to have a residential house. I just see it as different, and maybe that's just my interpretation, but.
What if you want to build a warehouse? You gotta have it rezoned. I mean,
That's what I'm saying, you got to get somebody rather than one person's opinion to go out there and get that rezoned. I still like the,
I think the answer is up to a certain size, you know, up to an area, square footage or something like that. That separates out the person who wants to put up some panels for their own use or whatever, and the commercial.
or if there's a buffer, I mean, in the situation that these folks was wanting to put it out there on wetlands, and it was going to sit back here, and you've got a lot of buffer around it, and nothing's going, you're not going to see it. That's one issue. But if it's sitting up by the road, and you know, somebody's got a nice home sitting on the property next to it, I see that the same as,
I think though,
not allowing.
I think though that if you're building that same nice home in AR zoned area, you could expect to have agriculture, you could expect to have farm animals, anything next door to you. Along with satellite dishes or anything else that people find obtrusive, you know.
Maybe one or two of them, maybe not 100 acres of it.
Yeah.
I mean, I'm just telling you, I have an issue with it, and I don't know the answer to it.
Well, this isn't just us. From what I've dug up on it, this is the question that's being asked everywhere right now.
It's statewide, certainly, because this program just came up and everyone's trying to wrestle.
Everybody's trying to figure out how is this, which category does it fall in?
Sounds like there's a concern about doing it as a conditional use.
I mean, I just still think that if somebody wants to come put this on my property, or on a property next to mine, I should be given notice, just like a zoning variance or anything else, that it's going to affect my property, and I think that I should have the right, or whatever property owner should have the right to give his opinion before a person makes an arbitrary decision to let something go next to my property.
It's not traditional agricultural use.
It's not.
And that's, I think that's the kicker. It's just not traditional.
So there may
Yeah,
be.
do I want the whole thing
Practice.
I don't, but I don't think the answer is this little paragraph to change the ordinance.
There may be a zoning that we could come up with where there are certain buffers, even if it's in an R1 or whatever. It sounds like it to me.
There's got to be buffer.
We can add, require industrial size buffering. We could require a traditional conditional use that has to come back to the board, where you can apply buffers yourself. Those are a couple of ideas, or we can require full rezone.
Well, this is one of those instances where I was hoping somebody would have something out there to say.
Yeah.
But, what's the board's wishes on this?
I would have to personally deny it until we have something more stringent or some guidelines, because I have the same issue.
But we table in that instance where it can be over. I don't know, I'm just asking, it's your motion.
But what kind of guidelines do we need to?
It's the same thing, I don't know whoever she just researched this.
Exactly, I came across a couple of them.
You're probably going to see ACCG has it. Surely there's other counties.
I knew you had something to say. I knew it. I was sitting here.
Trouble. Again, Jack Allen from Clio. Folks, why don't you table it and let's get the newspaper to do something and see if we can get some solar people to come in and get their comments.
Oh, we've had several solar people wanting to put them up. That's what's gotten us to.
But I mean, you get a consensus of what they want as well
Well,
as.
solar panel folks that want to do it as a business, they want it to be considered agriculture use. So that, because it's about taxes and cost, and that's what they would rather it be. And I tend to agree to a certain point, but then how do we draw that, that line?
What about rezoning the other area like we do with mining operations, and then they revert back and rezone it?
I don't see a problem with that at all. The issue with this particular thing was they were in such a rush, they wanted it done last time. If we just say that it has to be rezoned, that's fine, they just have to wait till the next go around.
But again, I think the point you made, Mr. Chairman, is as long as it's put on the roof, but if it's something that's freestanding, it should come back and be approved, I don't.
There's nothing stopping them from putting it on the roof now, is it?
No.
Or freestanding. I think the question
For their own use.
and it's when it gets into be a commercial enterprise, when it's a business.
Because do you agree if you had property next door to you?
Well, I certainly do, yeah, I certainly do. I'd hate to see a farm there, same thing I'd hate to see, Georgia Power coming in, build a big plant next to me.
But maybe.
But I think they ought to bite a pile that anybody creates.
I would say based on the conversation that's being had tonight, that the majority is not in favor of doing it conditionally, so you should just reject that and then possibly have, George work on a couple of different options for us to consider as an ordinance that we could approve. So when someone comes before us, it's a different zoning, that they're looking for, that we can agree to by the next time they come around.
Okay.
Do you think that's still?
Or maybe it can be a conditional use on AR1 property. However, you've got to have certain buffers in place, and you have to give, like, for an assemblage permit or something, you've got to give notice.
Well, conditional use has to give notice if it's approved by the board. This one, because they were trying to get this short time frame, was going to be, currently the only conditional use I approve is a second dwelling on an AR1 property.
So normally we'd have to do this anyway.
Yeah,
It's
so-
a special request.
Yeah. We need a way that if we have something hurried like that, then it can come straight here maybe without going through the planning board.
There, zoning, yeah, the state law doesn't allow that.
But that's what these folks was doing.
They were hoping that would be.
That's, yeah. And that's why I questioned why we were even hearing it to begin with, because there was.
So they requested to try to come up with a way.
As a
Really, they were
presentation.
hoping you would say it's allowable in AR1, done. That's what they want.
It's covered under the category.
Yes.
Yeah, that's what they were.
That's what they want.
So what they were hoping for is, and how it would work right now is if we had allowed, we would have to say, okay, we're going to assume that this is compliant in AR1, but with conditional use approval, which would mean that if any neighbors come up and complain about it, then you would have some sort of a layout of where they're going to be placed and if there's buffers and such as that. So the question, really what we need to be focusing on is, are we going to consider this an agricultural use, or are we going to consider this an industrial commercial use? Then we know which way to go with what zoning we need to do.
Because they said we were basically going to say it's a barn.
Right. So that's the question at hand, is this agricultural type, harvesting? There's a lot to argue that. And I tend to kind of go with that up to a certain point, you know, and I don't know that the conditional use isn't the best way to do it.
Agriculture grows on the ground.
I can tolerate a tractor next to my house versus 5 acres of areas coming out of the ground.
But I mean, if you're doing away conditional use, then you have to control where it's placed, along with buffers and setbacks and that kind of stuff.
But it needs to be worded a little better than this, right? So since you got it under control, you want to make a motion as to how to
I'm
do it?
saying, I went and did some homework on it.
I see power generation not as agriculture.
If you want to table it, I can bring it back to you as a more strict conditional use, traditional type is going to go through the board, and or we can consider it as an industrial use and they just have to rezone the
How long would it take you to bring that back?
next meeting. Or 5 minutes, go and run it back.
No, August 6th?
Certainly.
All right, can I have a motion to table this to the August 6th meeting with George to bring a revised version, recommendation to the board?
I'll make a motion, we table it to August 6th, with George bring back more information.
Second.
First and 2 seconds.
Mr. Jack, we did what you said anyway.
All in favor?
Aye.
And opposing, it carries. That is the last item on the planning board agenda. Thank you, Mr. George. You're welcome. Final place.
also read to 2014, correct?
Folks, can y'all hear? Joe, you may want to pull that microphone closer. Or I keep leaning.
If you turn to page S25 of your current budget for the fire department, which is department number 55, you will see a recap of current expenditures and current revenues. Our current budget is at $2.3 million. The current revenues that we have, that we're receiving at our current residential rate of $55 per household structure, gives us $881,000 basically in functional revenues. The proposed rate is at $80 per year, which would be a $25 increase. That additional increase would basically provide this particular fund with an additional $375,000. If you recall, within our service delivery agreement, we were allowed to move funds that were from the insurance premium along with in lieu of tax and our franchise fees over to the special tax district. In doing that, we then use those funds to fund various unincorporated type expenditures, including fire, the senior citizens, and also to water and sewer. Last year, there was some discussion in which we went through a whole series of calculations, whether or not we were going to impose fees with churches, whether or not we were going to impose fees with raw land, and so forth. In this particular scenario, we felt like that with Goshen Road coming on, some additional changes within the cities and so forth, that we needed to go ahead and propose raising these rates. We believe these rates to be comparable to other rates within our surrounding counties and certainly within a privatized type entity. There has been some discussion of possibly increasing it beyond that. I made those calculations. Those calculations basically would be something in the range of, to totally cover this particular fund, would be about $155 per household versus the $80 that we have proposed at this particular point in time. We have gone through these budgets with the current fire chief and believe that we have streamlined those as best we can. However, there's some additional discussion as far as where we necessarily locate additional structures and to increase the ISO ratings and so forth. Those discussions, along with additional discussions about consolidation of different with different entities and perhaps other municipalities, as we did with Goshen Road, are still in discussion. And so, at this particular point in time, I think Charles probably has a few
basically, the 80, as Joanne said, 80 is what we propose, just as a number to stick in the budget. 155 is what it would take to totally fund it. Anything in the middle, or, it's completely up to the board where they will go with this. In service delivery, the board agreed to build 2 additional stations, Hodgeville and Tuscaloosa. Hodgeville and Pinor. When Hodgeville comes on, which will be the next one, we're looking at 6 additional employees from that 24 hours, or 9. nine additional employees to actually be able to operate that station. Again, these were things the board agreed to in service delivery, and then I know obviously in the future. So whatever we do at this juncture, we're going to be coming back and having this discussion again in the near future. Because the commitment to create these stations has already been made. The personnel has to be put into them to get credit for them, and that also requires funding. The $80 that we have contemplated in the budget is obviously insufficient to completely fund fire, as evidenced by the 155, and that's based on today's budget, not the budget with the additional station and the 9 additional employees. So I guess it's really up to the board what level you want to fund and what difference comes out of the special tax district, which is obviously being depleted also. There's a fine amount of money.
Before the board takes it up for discussion, I know that any time that fees are to be raised, or anytime there's more money coming out of the population, it's not popular. So if there's anybody here that wants to have, I'm ready for it.
Stephen M. Thompson. Commissioners and Chairman, y'all just went up last year, like I say, on the sanitation. Now you went up on the fire fees. You went up last year on fire fees. And I keep getting the theory here that the fire department is spending more money than they got. So you're trying to get it from the citizens. You're building stations everywhere. When you build a station, you got to have equipment. You're buying these $1 million equipments, big pickup trucks, all the stuff to run around in. And you build a $1 million and something station down yonder at the county line, which should have been put in the center of the county to cover. That department covers just that area down there. It's probably costing Rice, Hope, and all them we cover. It's not helping this side of the county, north end of the county, nothing. And now I just heard that you want to build more stations. You want to build one in Pine Order. Let me ask the question there. We got one on courthouses, well, say 3 miles from there. You got one right down there at the substation, it's 4 miles. You got Guyton there, it's 4.5 miles from where I'm at. Right where I'm at. But my ISO rating, still the same in the county. I already checked. Do y'all know what the ISO rating is?
The county?
Yeah.
480.
Y'all didn't know it's 4. I checked on it. But I heard a little rumor that it might go up. So I'm saying y'all want to turn around and add $25 more to the citizens out here. All the citizens in the county is paying for this. To me, is outrageous fire. I know you got to have fire departments, you got EMS, all this stuff. But I see so many new equipment, and these trucks don't come for $30,000 and $40,000. They're $150,000, $200,000, $3,000 trucks. You got them running around here. I just can't see how you just keep wanting to add the burden to the citizens out here. You said something about the insurance premium stuff. And I just can't see it. And you keep spending money that you don't have. So we'll just go ahead and build a building. We'll buy a new truck, because we'll just add it and put the burden on the citizens of the county. There's a lot of citizens out here can't afford it. And I just think there need to be some looking into this stuff. It's just an idea to come up to the fire department, comes up here and says, oh, we want to build a building. That's fine. But you can put in that building. But you got to have trucks. But you're still using volunteers. Is them volunteers getting paid? No. You got a few paid firemen? That's fine. I'm I know it costs me, because I got stuff. And I just can't keep raising. Where's it going to stop? And I just heard a little thing there that it might, from $80 next year to go to $115. Where is the stopping point? Just like we're talking about sanitation. Where's going to be the stopping point? I mean, I hope y'all look at this thing and go away, because I'm telling you, keep on going. somebody buy me out, I'm going out of this county. Bam. That's why I just thought I'd bring your attention. And a lot of citizens out here has looked at this thing when it come out to put $1 million and something station right down yonder, which should have never, to my opinion, should have never went there. Could have went over on Goshen Road, Hodgeville. Talking about building an apartment on Hodgeville right now. Talking about building a Hodgeville. Why did it go right there at that point? I'd like to, I ain't nobody been able to answer that. Why did you build a big old glamorous fire department right there at the end of the road?
I came in after that. I don't know. That question was asked to me today. That was already agreed to, and maybe some of you guys can elaborate. That it was supposed to get the next two departments were to go in Hodgeville and Pineville, but instead it ended up in Goshen. So I don't have an answer.
I voted no to that location.
I did too, and it's in my district.
I'm not saying, I mean, I'm looking at something, if you're gonna spend that much money in that thing, is to put it, okay, let's look into a central location of the county.
You can't, that's not the answer. You can't have a central fire department for the entire county.
No, you still got a department, but why?
Service delivery was a process we all went through to determine these 5-mile radiuses on these stations to try to improve ISO ratings in the county. Now, the argument is, does the population, does the taxpayers, do they want us to increase the level of fire service in the county so that they can recover their money in lower insurance premiums with better ISO ratings? Or do we do nothing and have high insurance premiums? I think the argument is, if you have no fire department, you're going to pay more money than what these fees are a year in higher insurance premiums to insure your house, unless you're willing to live with no insurance. So the population, our friends and neighbors, this is the direction they want us to go. That is fairly clear. People want more services. That's why your taxes go up. Services have to be paid.
Right, and that's what I'm coming to now. The service, we paying for the service, but we still pay property taxes. And that property tax, what we get is, on service, is the sheriff department and the road department. EMS, they come out here and get you an ambulance, but with that fee on that ambulance, you're going to pay them a big fee. So they're not donating that.
My taxes include a lot more than that. I pay for the school board, the hospital, and
Wait a minute, I ain't going to school board. You don't want to go there. Because I ain't got no kids going and I pay over $5,000 school taxes. So let's don't even go to the school board yet. But I'm just saying, the fees that's coming out here, and I read in the paper that you don't only want to give the sheriff enough to pay the deputies out here to run the roads and stuff that he really needs. We need that as much as we need the department. But I'm just saying, look at the stuff you get and where you put in the departments. Like I said, I got one right on the courthouse road, 3 miles from me. One right down the road, 4 miles. If you put one right there at Pine, if you put one in Pine, is my ISO rating going down? No. You know why? I don't have a fire hydrant sitting within 1,000 foot of my house. Now they'll tell you that, insurance company tell you that. If you don't have a fire hydrant within 1,000 foot of your house, your rate won't change. I don't care how many departments you got, how many trucks you got, or how many men you got right.
I don't know what the surrounding municipalities charge or counties. I know in Bloomingdale it's $144 a year. So I don't know what it is. You said moving, I don't know where it's.
See, we're going right back to what was said on the sanitation. We are a rural county. We're not a city. We're not a county like Chatham County, all these other counties. And everybody wants to move this county to a city. And so why don't we just say, okay, we're going to do this, and we're going to put departments at every other door. We'll have street lights at every corner, red lights. I mean, let's stop and look at this thing in the issue. We're a rural county.
Street lights too.
And we got, I pay for them. I got street lights. At 17, I pay for them every one. They don't issue them.
Right. I'm just saying, people
So,
call for more and more.
I don't know what all the counties around us. I know Bryan County's $240 a year on their fire crew.
John, if we raise it to $80 from 55,
That's exactly where you're going right now. Just, it's the same way it's in there. Well, we can't get it in the fire fees. We're gonna slap around here and get it on property taxes. See, the fire fees was coming for the fire departments. That's what you're paying for. It's like sanitation. We're paying, the citizens paying for the sanitation.
Well, when they moved the fire departments from mostly volunteer fire departments.
That's right. We come from volunteers.
Then that's what caused the additional cost. And that was the beginning of increasing costs in the fire field. And now we're building buildings, but it's the same thing. That was the starting point. We used to be primarily volunteers.
That's correct. It's still volunteers.
Not a very high percentage anymore.
So you got firemen at every structure we got in fire department to run them trucks?
I don't know the exact percentage. Maybe
No,
like,
they don't.
Maybe you'd like to speak to that.
I didn't understand the question.
We have a paid fire person at every station.
No.
No.
I have one at 5 of my stations,
One at 5 of the stations.
on a 24-hour basis.
And that,
We
and
may
that
have
way,
5 stations.
their purpose, as I understand, is to expedite the delivery of that vehicle
Yes.
out of that fire and get it going, everybody else then converges on the scene. Is that
Yes,
basically
and
the
they
philosophy?
coordinate the response.
How many total paid employees do you have?
I think I'm up to 24 now.
Amen.
24.
24, but they're not all full-time.
They're all full-time.
Yeah, 20 full equivalent.
And you-
full-time.
According to his 2012 figures, he actually has 66 in volunteers.
Yes, and that fluctuates daily.
Yeah, you want to put my record is all that security with that.
And the number that I heard, right now, we would have to be charging $155
Yes, sir.
to break even.
Yes, sir.
Well, I'm still an advocate for people paying fees rather than paying. You can call it whatever you want, but if I own a piece of property that I have a dwelling on, and I pay a fire fee to protect it, in my particular house, I call State Farm, who carries the insurance on my home. When I built that home, I was a protection class 9. Today, under the 4 that we are, I save almost $800 a year on my property insurance.
And you're paying $55 to save that $800.
And I'm paying $55. I'm used to building in other counties. I build residences. In Bryan County, I go to get a building permit, and the day that I get that permit, if I buy that permit in January, then I pay, at the time a permit is issued, I pay for 1 year's fire fee. If I buy it in April, I pay 3/4 of a year. If I buy it in July, I pay a half a year. And I'm just going on record, I have asked for a long time, why does this county not do the same thing? Because whenever I start a residence in Effingham County, I am expecting the fire department to protect that dwelling that I am building, and I'm getting protection for that, so why should I not pay for it? Now, do I like spending more money? I don't either. It hurts my bottom line, but I think it's the fair thing to do. Bryan County, I know, is $240 a year. When I first heard that, when I bought the first permit, I jumped about. But then whenever I started looking and looked at, I've got friends in government down there, and looked and saw how they were paying for all of their costs and everything, and was not having to supplement as we are doing, it made a lot more sense, because everybody is paying for a service that they're getting. And I don't think anybody wants to go up on property taxes. I don't. I don't think any of this board wants to.
No.
But I think we're to the point, regardless of how many people line up and object to it, we've got to have money to operate a fire department. And I think the taxpayers get more of a benefit in a reduction of their insurance premiums than what they are paying to get that reduction. So I see it as a net gain to our citizens. If we go up on property tax to pay for it, it is out of their pocket, because if we quit supporting the fire department the manner that we are committed to do, your rating is going to go back up, and not only you, Mr. Mack, but myself and everybody else is going to be paying more money out of our pocket.
You know, and one other thing I'll add to that too, I don't like the idea of increasing this fee, all right? But the alternative to that is the money has to come from somewhere. We're gonna have to increase millage or whatever. We're gonna have to tax harder. With a fee-based structure like we have, some communities don't put it in a fee. It's all in the budget. It's all hidden in the budget. So then whatever money is needed is put out in tax on people. So they don't see this fee number. But what happens with that scenario is, with our scenario, every dwelling pays a share of the cost. No dependence on the value of the dwelling. Each dwelling has the same amount of risk, same people. So with a tax-based structure where there is no fees, then people pay proportionate based on the values on the house for fire protection, when everybody has about the same risk for a fire to break out. It's not dependent on the value of the home. So I don't like the idea of the fee going up, but the alternative is the funds have to come from somewhere.
Well, I understand that, but I'm still saying the point you're not looking at is you're building in these apartments, you're putting these big $1 million stuff, you gotta stop. Put you in interest. You got a big old building you got, and you're at a point, and it's gonna cost you another $1 million to add to that building. Do you have that $1 million to do it? No. So I'm looking at the point you keep spending money that you don't have. So, we just go ahead and do it. We'll build this, we buy trucks, we got big old pickups and vehicles running around everywhere, departments. With money that you don't have, we'll just add it, we'll charge the people. We'll charge the citizens of the county. They'll pay it, no sweat. I know they want to get the ISO rating down, but I'm looking at the point, you don't spend money you don't have. And just like you said, and like you just said, okay, it'll probably be 155 next year. Next year, knowing this, it'll be 200. But it's getting out to the point, you look at what you're spending and where you're spending it. And I just said, you got an apartment 3 miles over the courthouse, you got one fully. They're gonna put one in that. And he said 5-mile radius is what you had wanted the department. Everybody wanted to be in a 5-mile radius. But now you put them in a 2-mile radius, 3-mile radius at certain points. Then the outline is not, and it was on the map, it was outlined in 5-mile radius for each station. Right now you're overlapping that station with another station. Now you're overlapping that station with another station.
It's a 5 road mile radius.
Huh?
It's a 5 road mile radius, actually.
Right. I've rode the road because at one time, Guyton wanted to put an apartment on courthouse. We rode it and went, it was maybe a 1/10 of a mile down the road, but the department needed to go there to stay within the 5-mile radius. And I don't know, I just think it's getting a lot outrageous.
Understood. Anybody else wish to? Well, political suicide probably, but I'll just go ahead. I've told Tossin and the numbers that I have run, I think $80 is a conservative figure. I told him to propose 100. I did not think we need to hit this 155 all in 1 year, but I think that it's the place that we're going to wind up. Just like Mr. Mack said, I don't see a way to avoid it in the end. But I would like to see our county, whatever we do, I think we need to start collecting it on a pro rata basis, and it's not just Bryan County that does this. Every surrounding county that I've called and talked to does the same thing when they're permitting. And how much additional revenue that creates, I don't know, but it's the fair thing to do.
Well, Mr. Chairman, that $155 was based on raising it so not upping it on business or industrial. I see you trying to run some numbers now. I don't have that for you, but that was based on solely raising a residential, which again is not equitable either. So I would suggest if you wanted to do that, let's maybe look at some increase on businesses as well.
The issue that we had last year was that the number of commercial, at least according to what I have from last year, was,
We raised our business last year.
yeah, it was.
You raised industrial, 2,000 here for industrial.
We raised.
They were actually trying to reduce the industrial.
Reduced.
Yes, sir. It was a much more complex chart there were a lot more categories than what's in here now.
The highest they rated at 4 in this county for industrial, that's a huge savings for them.
Well, I mean, that's what the proposal was trying to reduce it, and it ended up defaulting back to what it was previously.
I think in the past, as far as the charges on industrial, there was maybe 6 or 7 that were charged at the 2,000 rate. Commercial, from what I'm showing right now, was around 350, it looks like, that we had. And then,
There were only 6 or 7 that fell into the category, and that was an increase for them.
and that's why there was an issue. We did discuss doing something as far as rural land, and the fact that we do pay Georgia Forestry. I think we talked about either a parcel amount or a acreage amount last year.
And it is unproportionate, I agree 100%, because although Walmart's in the city, if Walmart was in the county, it would be $80 for my house and $250 for Walmart.
What are the cities, do we know their current rates? Our fees?
It's lower than our 55.
I thought Rankin increased theirs.
They say they're expecting an ISO decrease. To me, it's going to agree. I said that's what that's what I was told.
And that's pretty much it.
That's what I heard. You heard that? That Rankin could go to a 3 ISO?
That's what I'm thinking, but,
Based on that new hose thing that they bought?
Yeah.
Well, Leslie indicated that he thought it would.
yeah, it was based off of buying 2 more trucks. And I think they found in their letter, I'm not sure, I have a meeting this week with the chief, that,
They were trying to get a letter.
yeah, the letter's been presented to Chief Ron, from what I understand. And basically it told him he had to hire more personnel. It did not rely on the trucks, and that was moving towards staffing. And I wasn't at the meeting, but I heard that the board had decided to abandon that and not go for the amount of staffing they were asking for, which was 29 additional personnel. That's what I've heard. This is all just...
It was 29 personnel, I'm sure they did not approve that.
Yeah, I mean, you know. But the fact is I mean, and it's across the board, it's everywhere, it's Rankin, Springfield, Guyton, the county fire departments. Our call volumes have increased. So,
Well, I personally, I guess I can say that I feel based on what has been presented to us tonight is, based on what we did last year, we raised the businesses last year, they may need to take another look, but I think that may be something we need to look at next year again, and comprehensive, if we're still not covering all the subsidies, but this is a start. And it's not hardly painful. It's not taking it all the way, covering the cost, but it's a start.
If we raised it as suggested by the chairman, that would provide, in addition to the $375,000 that we were proposing, an additional $300,000. So you would then be proposing to subsidize the fire department from the special tax district at right at about $700,000
Instead of $1 million, if we went with 100 instead of 80.
Correct.
Clear.
That's correct.
I'm telling that I think we need it.
I agree we need it, I just can't go that much around.
I'm comfortable in going with what's been recommended here. I don't think we should almost double it. It's 55 now, I don't think we should double it.
I don't like having increases at all.
figured out how much this money this is gonna generate at $25 per
Ma'am.
household?
No, I'm sorry, please come and put in the station name.
The report.
That's the numbers Joanne
Yeah,
just.
375.
Just gave.
And repeat your question, please.
I'm Joyce Thompson. And I'd like to know, Joanna, from you, how much money is this $25 gonna generate for the fire department a year? Have you figured it out?
Yes, ma'am, we anticipate.
Pardon? We're hearing aids, so you're gonna have to speak up.
I'm sorry, we anticipate it to be $375,000.
Just that little bit?
Yes, ma'am.
I think you're a little bit wrong, because there are a lot of citizens in this Effingham County.
There's a lot of houses in this county.
We understand that, but we're only charging those that are within the incorporated area, and our particular, from what our GSI department is telling us, the household count, the overall household count would be around 15,000.
What is the fire department planning on doing with this extra money that they're gonna get? What kind of benefits are they gonna offer us?
Well, they're already spending the money. I mean, it's being spent every year now, but we're taking and subsidizing from the
Right.
general fund, from other monies now.
Right.
And that money
Okay.
keeps.
How many paid firemen do we have in our county? Do you know? I don't. How many?
21 full-time.
Pardon?
24.
24. How many stations do we have?
10.
10. How many firemen do you have at each station?
Average one a day, 24 hours.
2?
500 stations.
Where are these stations located that you have a fireman at?
Falkville, Meldrum, the central station, which is courthouse. Clio. I'm missing one.
North.
And
Shawnee.
Okay. All right. I have an example. We had a fire. I worked at H&R Block. We had a truck on fire, a semi-truck. The fire department did not get there until after the tires exploded on it. We called the sheriff's department 3 times and told them exactly where it was at. And it taken them 40 minutes to get there.
Where was this at?
This is right here on Highway 21,
City of Springfield, right?
right there in front of Harvey's.
Yeah, that's City of Springfield.
Pardon?
That's City of Springfield.
That's City of Springfield?
Fire Department.
Okay. Do we assist? I mean, we had a truck there with diesel fuel and it was going to
We
explode.
weren't paid.
If they need assistance, they call for help.
And even if they
The county will
weren't
back
called,
up and meet the
Yeah.
city.
if that location would have been called for assistance, it would have been Rankin Fire.
Okay.
Not
Well, I
the
mean,
county.
it was just,
I
it
know
was
it's
an
typical.
unusual situation, but we sat there and watched the truck literally melt down. So, all right, that's all I have. Thank you. I was just wondering if y'all knew how much money you were going to get.
Yes, ma'am.
Let me ask one more question. How many house counts did you say there was in the unincorporated area?
According to what we pulled from the GIS, we believe it to be around 15,000 households.
In the unincorporated area?
In our fire district, part of the unincorporated area is covered by Rankin and Springfield and Guyton.
Yes.
So it's 27,000 parcels in the county, take out what the municipalities are covering, and so it's roughly in the 15,000 left over. That's about the house count. That answers the
They
question.
want to know the number they billed for last
So-
year. How many they billed last year? Roughly.
Huh?
We should know the number of houses that we built last year, and we, you know, it's gonna be roughly.
There's a lot of them in this county, I'll guarantee you. There's a lot of subdivisions and stuff in this county too. There's a lot of houses I think it's not, but now is Guyton and, let's use Guyton, they are covering a 5-mile radius? Is that the house count they counting, or are they counting just within the city limits of them?
We still collect on all houses in unincorporated,
That's correct.
then we pay them back.
Must not be read right in the right county.
Ms. Beth has something to say.
Yes, my name is Beth Mosley. I was just going to say that, and I don't know exact year, it would have been in the 80s, like the late 80s. When I lived on Tulahi Island, we were paying $80 a year.
Non-incorporated Chatham
Unincorporated,
counties outside of fire,
Tulahi
the
Island.
fee is about $175 a year. That's the minimum.
Yeah.
And it's based on square footage.
So from a fire standpoint, obviously Effingham County has been picking up the cost of fire by using money from the general fund. What this board and what the previous board has been doing is moving more towards putting all the fire costs in the fire fee, but not all at one time.
Right.
And because it just would, it's just not practical. So we're still going to be, it's not a new fee, it's not new money, it's just money that is not being taxed in your regular property tax that's in the fee. So if we don't go up, your taxes will cover the cost. It's not new money. The fire department's not getting more money. It's not an increase in their budget. This is basically what's been being covered by the general fund.
And we've done this in numerous areas. You know, we've looked at the fee schedules within the general fund so that people who are receiving certain services are charged for those services to decrease what we have to charge in property tax. This particular fund is an enterprise fund, and we are doing the same thing within this particular fund, is trying to make those funds and those services self-sufficient based on the fees received.
We understand.
So the question is how much do you go up?
Let me give you all another point. I don't know what the chief knows. They respond to all these accidents with 2, 3, 5 trucks. I understand you got to get to the accidents, save lives stuff. But every one of these accidents where they need a fire truck up, they respond. They, in turn, can bill the insurance companies. But that, responding to that accident, are y'all doing that?
No, sir.
These insurance companies pay $50 to $100 for any respond unit. You need to check into it. So you figure how many times they go out. That can come up with a lot of revenue money. It won't come from us. It'll come from out of these people having accidents and
I'd say checking that, if that's true, that's something we can follow up on.
We did, at one particular point in time, bill for different services, and Eric, you'll have to help us out on this piece. I believe, anyway, that there was some sort of legislation that prevented us from being able to do that.
I think there was at the time I had been asked to revisit.
We will look into it again.
We'll definitely look into that.
because that, I mean, I knew when I was with the fire department chief in Bloomingdale that we responded to an accident, you can get the rates that the insurance do pay for responding.
If there are any ideas like that, that's all that's worth looking into.
Right. Because I mean, I know we're going to fire department stuff, but we need to look into helping out with the sheriff's department. We're going to do that.
And the fire department responds because every firefighter is a trained EMT, correct?
No, they're not trained EMT, they're trained first responders. I
First
have some
responders.
trained EMTs,
Okay.
but not all of them are EMTs. A volunteer could not take the time to do that. It takes too much time and money.
You know, I'm talking about your full-time.
Not
people.
full-time, some of them are EMT certified, but not all.
But if they're EMT certified and they respond to, I mean, you get a call for somebody having a heart attack. What is y'all's method from when that fire truck rolls that's got an EMT on it rather than an EMS or in addition?
They're responding.
What is y'all's criteria?
We respond together. If I'm understanding your question correctly, we respond together.
Together?
Yes, sir.
In all circumstances?
Yes, sir.
Is there a reason for that?
It's
I mean,
gotta
it's-
be policy, procedural.
Well, it's a policy on my part as far as the fire department. We're paged out to it. We have to go. Once we're requested, we have to respond. But it's, I think in the past, we've entertained the idea of stopping the fire department from running the medical calls. And it was kind of a legal battle because we'd already started it. And if we stopped it at some point, from what I understand, you know, it would open us up to liability. That's the way it was explained to me.
Who explained that way to you?
Val.
But that it has to be initiated through 911, because if you're dispatched, you have to go.
Yeah, if we're dispatch, and we're dispatched.
Does he have legal?
Well, I don't know where that come from. That apparently come from a meeting that was relayed to me. I mean, I was the battalion chief. I took his orders and ran with them.
I do remember having a meeting where we talked about having a, what do they call it, a hot call policy or something?
Yes, and we tried implementing that, but what that boiled down to is we've got some fairly big people in Effingham County, and our EMTs can't pick them up. There's times when it takes 6, 7 firemen to get in there and pick them up. I mean, I'm sorry, that's just the way it is.
I appreciate it if you.
Let me also say though that within the current budget, I believe that we put some funds in there for smaller vehicles so that the
Yes.
fire department could respond without, okay,
Rolling the fire truck. And that's kind of what I'm trying to move to is some of the calls where we know that it's just lift assist or a medical call where we don't need everything off that fire truck, that we don't have to run that fire truck that gets 9 to 10 miles a gallon.
Well, I think that's what the citizens want to know, is that we're doing everything that we possibly know to do to obtain income from other areas. It can be from the insurance company, or if we can reduce unnecessary costs, and if we're planning smartly, they want us to prove that that's what we're doing.
Yeah, and there again, in the past, it was explained to me the reason why we did not bill the insurance companies is because of the way we received our funding. The law did not allow us. Now, since we've changed the way we receive our funding, that may be an option.
Is there generally things to look into?
Is, a number that was given to me one time was about a $400 average each call, every time.
That's what it cost.
Yeah, that we would spend
Yeah,
around
that's
$400.
That's an average, yes. It may have went up. I haven't run that particular number. I do remember when Val run that number, and it's probably went up since then. I mean, unfortunately, I'm just not getting the volunteer base we used to get either. You know, you've got the citizens that would normally volunteer are having to go out and get 2 or 3 jobs to support their families. They're not able to spend the time with the fire department like they used to.
Any other questions? Well, I'll still go on record for saying I'd love to have a motion from this board to increase the fire fee to $100 plus look into whatever we have to do to change it to flat and pro rata, but I don't know that I'm gonna get that, so I'll take what I can get.
I think looking into the charging earlier is something that we need to do. That's something to deal with later. That's not part of this right here today. But I
We
think
can direct that, we can go ahead and look into that.
That's what I like.
All of these areas of savings and additional income, they need to be directed to look into all of those, provide that information to us. But as far as this goes,
I'll make a motion that we approve the fire fees as presented, and also direct staff to work on prorating as new construction permits or requests.
board member, we're gonna move a couple of things forward, help expedite a couple of issues. We're gonna go to item number 16 next. No, item 15, I can't read. Item 15. Consideration to approve a professional service agreement with the Effingham County Chamber of Commerce. Mr. Lott?
Good evening. I'm Rick Lott, Director of the Effingham County Chamber of Commerce. Excuse me. What I have before you here tonight is really not anything that increases what you've been doing as a partner with the Chamber at all, but just changes how we're dealing with it. I think it may be helpful in several different ways. The Effingham County Commission has been a member of the Effingham County Chamber of Commerce since 1987, which I think is a wonderful thing to say and remarkable. It means that the county and the Chamber were partners at the very beginning of the Chamber of Commerce here. We feel that the nature of this partnership might best be couched as an agreement for services between the county and the Chamber rather than the previous dues structure. So the Chamber has created this agreement for services which details some of the services the Chamber performs for the county which benefit the citizens of the county. Events like the Effingham Day at the Capitol, the Community Leadership Retreat, Eggs and Issues Breakfast, and many, many others strengthen our county, foster an ongoing dialogue between the county and our cities with other community leaders. These events are very expensive to produce, and it's only with the support of our county and cities and others that these events can be continued. The Effingham Day at the Capitol in particular is a great opportunity to appear before our governor and state leadership presenting a unified community front. Our Community Leadership Retreat coming up in August is another example of strategic planning on a community-wide level and one that produces tangible results. Areas of focus at last year's retreat included transportation, commercial development, local workforce development, and recreation and tourism. The Effingham Chamber is excited at the work the county and the Chamber can accomplish in the coming years, and we appreciate the opportunity to talk about this continued partnership.
All right. Ms. Block, this is the agreement that we discussed one day over at your office, is that correct?
It is.
And this was presented at the same time as we were discussing the hotel motel tax.
It was, correct.
And my statement to you that day was it was my belief that several of the commissioners felt that they were giving you the hotel motel tax and it was best to wait to try and move this to a later date.
To avoid confusion between the issues, yes.
Good work.
And in fact, I'd like to point out that there's a huge distinction between what this agreement would cover and what the hotel motel ordinance revenues covers. The hotel motel is really geared in our intent and what we've expressed in the way of the budget for the use of those funds is really strictly for building tourism in Effingham County. This agreement covers predominantly the areas that are not tourism but that build community strengthening between the county, the Chamber, and all the other leadership entities that we have here.
Okay. Ms. Joanna, is it my understanding that the anticipation of this agreement is in this budget somewhere?
We generally put it out within Department 51, I believe.
51?
Yes, sir, under other agencies. And currently under other agencies, we had in the 2014 adopted budget the amount of $9,000 for the board to discern between fireworks, Old Effingham, and Chamber, what funds were to be expended.
That's the present budget.
That's the present budget. And within the current budget, we did not allot any funds based on some of the earlier discussions.
So this is presently not covered in the budget in any way?
That's correct.
Staff report says funding is included in the budget in Department 51.
Yes, ma'am. It's not.
It's not.
It's not, and you and I spoke at some point, after Mr. Locke and I spoke, it was not in the budget when you and I first had a conversation. It was my intent to put it in there. Ultimately, we did not, and it's listed on one of these slides here, the discussion for the board, because we knew it was all, when we here tonight, it was either, depending on which way the board went, we need to put it in.
Alright, so that's part of my reason for taking this out of order is to determine the wishes of this board, whether to execute this professional services agreement, which is my understanding that legally we can do, whereas we cannot legally pay dues.
Well, as clarification, that was one of the reasons that this got brought up, is because we basically found that the way we had been doing it was not really the proper way, and that there needed to be a contract of services. So if I understand correctly, we're not looking at increasing the amount of what the service that we've been provided. We're just really looking at getting a proper contract of services way of handling it.
Exactly.
So the question for the board is whether or not the board needs to enter into this agreement with the chamber
The amount for $4,500.
for $4,500 for the present year that we're looking at budgeting. And if there's no other questions or discussion, I'll entertain a motion at any point. If there's more discussion or questions, we'll get that.
I make a motion that we approve the professional services agreement.
Second.
Did I hear a second?
Yes.
Second from Commissioner Kiefer. All in favor?
Aye.
Any opposed? So carried.
Thank you very much.
Thank you. All right, next item to be taken out of order is item number 16, consideration to approve a refund as a result of ruling in 2009 and 2011 tax appeals and requests for interest payment owed and refund for assessed 2010 and 2012 ad valorem taxes paid by Plum Creek Timberlands Limited Partnership. Derek, you're going to present that, and I understand we have counsel here to answer any questions that we may have.
Yes, Mr. Chairman. Jay Roberts, the representative, the taxpayer Plum Creek, is here to answer questions. The agenda item summarizes it pretty well. It is a request for a refund of interest paid. Well, interest they claim is owed as a result of appeals in 2009 and 2011. And it's my opinion that that part of the request is not appropriately before the board because that's not what the refund statute is contemplated to address. The other part of their claim is for a refund of 2010 property taxes and for a refund of 2012 property taxes. The 2010 request is based on the fact that they successfully appealed in 2009. Their appeal from 2009 was not decided until after they already paid the next year's taxes. But under Georgia law, when you successfully appeal, the decision of the arbitrator in this case is supposed to be given binding effect for the next 2 years. So what they're requesting is a refund based on the difference between their 2010 assessment and the values that were set in 2009 as a result of the appeal. And it's my opinion after reviewing the statute and speaking with Ms. Bevel, who I think has spoken to the Department of Revenue, that taxpayers' position is correct, that they're entitled to a refund of the 2010 taxes in the amount they claim. And we have looked at all the bills and applied the millage for that year against the values and determined that they calculated the amounts correctly. The 2012 issue is essentially the same issue, with the exception of this fact. The tax commissioner actually issued corrected bills in 2012 based on the 2011 appeal for all the parcels but one. It looks like it was simply an oversight that the tax commissioner failed to issue a corrected bill on this one parcel in 2012. And the difference in what they're requesting is a refund of the amount of $2,464.04. We don't believe they're entitled to any prejudgment interest as they've requested and refund claim. The case law doesn't allow for it. And we don't believe their 2009, 2011 claims for interest are appropriate either. So in sum, what you've got is a refund request of $80,072.66 for 2010 and for $2,464.04 for 2012, which we believe are due based on Georgia law, which establishes that once you've successfully appealed, your values are reset for the next 2 years.
So can you recap in a bottom line what you're saying that the law says we should be doing?
Based on Georgia law, they would be entitled to the refund for 2010 in the amount claimed of $80,072.66. And for 2012, for $2,464.04.
Would council like to come forward, state your name for the record, please, sir?
Good evening, I'm Jay Roberts. I represent Plum Creek Timberlands. I would agree with Mr. Gottwalt, appreciate that recommendation. We would disagree about the interest. We believe that we are entitled to the interest, but there is another forum that we can address that, and so we appreciate that recommendation. And with that, I'm here to answer any questions that the commission may have.
Would this end the appeal? I mean, everything, would this finalize this?
It would end the refund action. We could take up the interest request, which is really more appropriately taken up under 485311 with the tax commissioner. The refund request, as you know, comes directly to you, so the interest can be taken up. So it would, that should be a ministerial matter pending the outcome of our request for refund.
But it's our understanding from our council that the only thing that this board should be considering is the principle, the tax itself.
Yes, and the law is unclear as to whether or not you can get prejudgment interest or post-judgment interest under 485311, which is the tax appeal statute through the refund. So there's no legal authority that I can cite to you that would disagree with that.
Any questions from any of the board?
If we approve this, where would this money come from?
I believe it comes from current collections on behalf of each of the entities for whom we levy. So it doesn't all come from the county. Some of it comes from the school board, some of it comes from the state.
That is correct.
Some of it comes from the IDA.
The largest portion being the school board.
I would say.
Come from school board, hospital authority, IDA, it all filters down program of just.
Even the state?
Even the state. And at this point, it was probably 0.25 mils.
But I mean, we are being told that legally they're due this.
And that's the way I would interpret the law. Ms. Bell also, I think, contacted the Department of Revenue and they would concur. It's unusual because the appeal took so long to be decided that the next year's taxes had already been collected at the time the decision was made in the arbitration proceeding. But I don't think that should defeat the taxpayer's right, to have his values established for the next 2 years.
And I could actually speak to
that. You could just delay the proceeding, and defeat the taxpayer's rights.
And I can explain the reason for that delay. This case was actually stayed pending the outcome in the taxpayer case, because it had an impact on our case as well, and so that was the reason for the delay. No, this was not a similar case. This was just a straight tax appeal where we were challenging the valuation and the methodology employed by the tax assessor.
I was sitting on the Board of Equalization at that time, and I remember seeing 3 pages that we were going to hear, and all of a sudden, y'all pulled them. And then they put them back on, and they pulled them again. This has been going on for a while.
Since '09, yes, sir.
Yeah.
Did we refund this and then it's up to the county to get it back to the school board and IDA, or does this go out, how does it, back to Steve's question?
So we collect for everybody, so the funds will be taken out of our disbursement.
I would imagine it would work the same way that they're collected. Once the property taxes are collected, they actually go to Linda McDaniel's account. She then disperses periodically to each one of those funding organizations. I believe Eric's right that it would come out of the existing funds. So let's say that she was going to turn over $100,000 to us, and our portion was $20,000. She would simply subtract the $20,000 out of the $100,000 that she was sending. Understand, however, that when we're recording our actual property tax, we also have a deferred revenue account. That deferred revenue account is for all other prior taxes that have not been collected. We can only claim income up to 60 days after we close our year end. So all of those additional funds that are for property tax that has not been paid would also go into that pool of money that we would be receiving from lender periodically.
But this has been paid, so this is a refund.
This is a refund.
Okay. It filters back out. We don't like giving up money. Can we negotiate?
No, sir. Yeah. My client didn't like paying it either.
Because what happened in these, if I would remember, when you appeal your taxes, you're required to pay 5% of the value, and then y'all won your appeals, so that money was paid, values were set down here, and now you're entitled to this refund.
And the refunds have already been paid for 2009 and 11 in full, almost in full for 2012, so it's just that one parcel for 2012 and 2010.
And the part that they can't go back, I mean, it has to come through us for that further period back.
And the refund request was made within 3 years.
So the total refund minus interest is
82,718.
82,718.70.
Yeah, that's my math.
Different from last page.
2010 of 80,072.66, so 2012 of 24.64.04.
Should be 264604.
Yeah, that is
That's
an error on the lawyer's part.
So that should be 24.
2646.
2646.04.
And by my math, 82,718.70.
So you were trying to give us a discount.
See?
All right. I'll entertain a motion if there's one out there.
You said that number, right?
Yeah, in the body of the letter, it's 2646.04. In the spreadsheet attached, that's my mistake. I have transposed those numbers. So the 82,718.70, I believe, is the correct calculation. Mr. Gottwalt might be able to speak to that.
You check them somewhere?
Yeah. So we have a calculator?
Let's see.
Steve,
I've got the
52.
Just added two of
That was
those.
4,414.48.
6,000, what was that first number?
6,878.52.
$6,878.52.
That is 2464.04.
I thought so.
Yep, you're right. It's wrong in the body of the letter. My apologies.
I thought so.
Let's work on that 80 number a little bit.
So that takes it back to the
82,536.70.
Thank you.
So 82,536. Sound? We sure the number is enough? I'll entertain the motion then.
As a result of the real 2009, 2011 tax appeals, I make a motion to refund Plum Creek Timberlands $82,536.70.
Motion and a second, all in favor? Any opposed? So carried.
Thank you.
Enjoy your trip home to Brunswick.
Have a good night. All right, thank you.
All right. I'm tired, ready to go home. Everybody wanna go home? Oh, it's not over. I just said I was tired and ready to go home. All right. She is not laughing, but. All right. Item number 13, consideration to approve a budget ordinance for fiscal year 2014. First reading being read for a previous meeting, July 8th.
This is a shorter slide presentation that we went through the first time. It simply is to give the highlights and to show the proposed first draft and the changes made to that first draft. Our original general fund budget started out at $26,755,171.19. It was an increase from this past year's budget of $351,169. You have already voted on the millage, which stayed the same at 8.558. This particular budget did show changes within the personnel staff. We gave you slide presentations as far as the individual changes by department. From the very first draft, that showed an increase of 38,000. That was with working with all of the different departments and trying to ensure that we were covering all of the new state mandates. The original first draft of the budget showed using fund balance of $400,642 and included a reduction in the projected loss receipts for the current year. This particular slide is an overview of the changes that were made from the first draft to our second draft with the modifications. One of the things that the board asked us to consider was on the calculation of the COLA and the merit, as far as the merit, and who, those particular individuals who would not be eligible for that merit. That particular amount calculated at $16,500, based on discussions that this board has had over the past several sessions. We looked at the Motorola agreements, which were also discussed tonight. Our original budget called for a little over $100,000 between the EMA budget for Motorola and also too the 911 budget. That would be an increase tentatively of about $85,000, depending upon how those agreements are structured, and any potential reductions that may be received, because we would not have, I believe, the one portion of that particular structure, which would reduce it some, but we do not know exactly when that will happen. And so we appropriated the funds based on what we think would be the maximum amount. We looked at animal control and we put some additional funds in there. We believe those funds can come out. This board voted at the last session to go ahead and replace the batteries, the UPS batteries, and that was at a cost of $17,000. So the new second draft of the general fund budget comes to $26,836,771. The second slide basically is of revenue. If you look at the first column of the proposed draft, most of those revenue sources stay the same. However, we did add some additional revenue that we received and believe will continue to receive from the probate court revenues of $10,000. We also, within the special funds, added the hotel motel as a special fund. The net of that, we would anticipate to have about $3,800 in revenue. With those two particular items added, and no additional changes as far as revenue, that means we would need to increase the use of fund balance by about $61,000. In doing that, then we would have a balanced budget with revenues showing at $26,836,771. This next slide is simply that same information, but shown by category. Personnel would change by $16,500 as a decrease. Purchases would go up by $85,000. Supplies would come down by $10,000, and we would have $17,000 in other. The reason that was put in there right for this particular moment is those particular batteries are across different funds, and we have not been able to ascertain exactly which batteries are at which locations and therefore which funds those would come out of. At the very worst, it would be a change of $17,000 within the general fund. The same holds true for the revenues, where we show the revenues located at the original amount, and the changes that were made to come back to a balanced budget of $26,836,771. One change I don't believe that we have slotted in a slide is we did add the hotel and motel tax for a special fund. That particular amount is within your actual documents and is shown at the back, I believe, of your book at $15,000 in purchases and $18,000 in revenue for a net of that $3,800 coming over to the general fund. This particular budget slide is simply going through and showing that the $26,830,671, that would be balance. Regarding the budget itself, we of course have been able to not have a millage increase. We believe that in shifting around some of the personnel that we have increased departmental efficiencies using staff that is applicable across the board. We believe that we're still maintaining a high level of service to the residents, especially in public safety. There is contingency included of $150,000 within this budget, and that the cost of living and the merit for the employees is the first that we have done since 2009. We went through the points of consideration at our last meeting, and we basically went over the fact that we still need to get some sort of mechanism in place with the hospital as far as that particular funding. Right now, that is funded out of a property tax base, but as far as the actual working of that particular contract, that we need perhaps to amend that contract and have a firmer ability to regulate exactly what the hospital receives at a particular time. As far as the fire budgets, you've already approved this evening the resolution to increase the fire fees, so that's inclusive of the the current budget. We discussed in the past about the short-term work program and rearranging that based on perhaps what the board may want to go in the direction of. You have already had the recreation board request some of their funds, and that's still before you. We have items currently that have been approved that we may need to rearrange where some of that funding is coming from. You're currently discussing the radio tower and that infrastructure, and there's still continuous discussions as to whether or not we simply do a part of that infrastructure upgrade, or whether or not we go ahead and put in the necessary equipment to expand that. As far as use of impact fees collected, we have gone through, I guess, the first reading this evening regarding impact fees and moving from impact fees, but keeping a cost recovery fee. And so we've made the first step there. Health insurance, we've discussed the potential increases there and the need perhaps for some additional funding in that area, or to relook at necessarily how we structure our health insurance. We have this evening adopted fire fees and have made gains in that area to make that particular fund self-sufficient, and adopted sanitation fees this evening. So we have solidified that particular fund. One of the items I think that probably needs to describe better is the need, or potential need, let me say, for what is termed NPO funding. And I think he can discuss better the attributes to consider with that.
I'm sure everyone on the board is aware of it. Savannah urbanized area now comes in Effingham County, which means we will be going into the core coastal region MPO. Part of that discussion revolves around what planning area will encompass, what portion of the county will be the planning area, which will somewhat dictate the fees. And I want to make the board aware that part of that will be the MPO coming to this board asking for us to fund that organization in part, to pay pro rata share. The initial goals, I guess, for the MPO is to have the reapportioned board in January 14. I personally believe that is a little ambitious and question whether or not that happened, but that's their goals, and that's the reason I'm bringing this to y'all, because if Mr. Thompson talked to me, he would say the reapportioned board will be in 14. So I want the board to be aware that when we come into that, there will be a funding request. However, from my standpoint, number one, I think it's ambitious. I don't know that it'll happen. Number two, the MPO approves a budget themselves, much like we do. It's called a Unified Planning, Work Planning Program, UPP. and their budget year is the same as ours, they went through and approved it not long ago. So they're currently funded up through June. I'm not sure why they would ask for money until their budget runs out. Thirdly, I believe this board should have input if they're going to be asked to fund it into that budget. And fourthly, we don't necessarily want to be there anyhow, so I think we could tell them, no, we're not giving you money till June. So I don't think it'll come up. I think that we're certainly fine to contemplate this in the next fiscal year's budget, but I do want the board to be aware that this is moving forward. A component of that will be funded.
We're probably looking at somewhere around 50,000.
Yes, so the initial estimates were somewhere around 50,000, that's correct.
All right, in the budget, the library, what is the library on? What? No,
It's on Department.
it's in Department 50 now.
Yes, sir.
Yes.
I hadn't seen it as,
The third from the bottom, G82.
Correct.
G82.
Yes, sir.
Yes, sir.
The third from the bottom.
So basically, we're holding them at the same thing they were last year, right? Which was a significant cut last year from what they requested. So this is one thing that's been brought to my attention is the library. And while we're increasing so many parts of the county budget and holding the library, what we cut them back so much on. Did y'all discuss this in the meeting?
They came, you weren't here.
Yeah, they were here, but did the board discuss holding the library where they are?
No, the first that I heard, that they weren't happy with the request was at that budget meeting.
Right.
That's correct.
I didn't know they were. At that budget meeting, that was the first time they spoke to us and said that.
I mean, the request was up again, but, we're holding them, and, I mean, if you go down the list, I know that the millage is staying the same, but if we're going to increase these other departments so much, and do a merit increase, and, why are we holding the library back after we cut them, literally cut them to the bone?
Did you guys have a meeting with the library like we do the regular staff? How does that work?
We did not this particular year. I believe, if I'm not mistaken, in the prior request, there was some capital items that were in that request. I believe those capital items had to do with improving, and correct me if I'm wrong, improving their tracking system. Is that not correct? So in looking at the particular amount of the 609 versus the 445 versus what they had requested in the past, generally a lot of the increase has to do with necessarily capital items that they want to put in place.
It was that, but they also severely reduced their hours of operation when we cut them so much before. And that's why I'm unclear on this, because I know that they want to go back to their regular operation hours.
Yes, sir. And in the past, I think one of the things that you need to remember also is that we actually increased our funding. That particular budget had been solidified by both the Board of Education and the county.
I remember
And
that
so-
after we took it over, since I've been on the board, I remember them coming up and they literally took it very hard. They worked with us and they cut it as much to the bone as they could. And I remember that.
Yes, sir.
And so now, our digest has increased somewhat, and we've got a little bit more money to share back around, and we didn't do anything with the library.
The increase itself, as far as in the prior years, I do believe had to do with capital itself. It wasn't necessarily the operational piece of it. I think there was some staffing that was included in the operational piece of it, if I recall correctly.
Do you remember what we were paying before the school board stopped? What we were paying something like something?
I believe we were contributing 200,000 or less, if I'm not mistaken, and we took the hospital's portion, and that to our current budget. As far as, you know, ability to help with additional capital items and that sort of thing, we certainly can look at doing that with perhaps, you know, if there's a particular item that they need.
And I'll tell you, I would love for the cities to get involved.
Yes,
You
sir.
know, I believe that the cities, and I don't remember discussing this in service delivery, but I think that would have been a great argument that the libraries that are funded is also, obviously, since one of them is in the city of Lincoln, you know, that.
What, was that addressed in service delivery at all?
I don't think early on it was discussed that that was a countywide service.
If,
I'm fairly certain, I can't imagine that Mr. Ziegler would not have brought up the library, because I know that was one of those things that we always.
But he didn't get really involved, right? He didn't get involved in the final service delivery.
if I recall correctly, one of the things that was discussed with not funding the capital was that the funding that they wanted was not only for a tracking system, but had to do with them enhancing their ability for movies and so forth. Is that correct, Evan? And it was deemed at the time that the board did not wish to necessarily invest in that particular aspect of the library. But we certainly can find ways, or perhaps look at particular capital funding that may be done with some of this SPOS dollars, as we have done in the past, like with the hospital.
What I'm looking at here is some of the same departments, and not that I don't agree that Judge Mosley needs her increase,
Yes, sir.
but that was some of the same ones that was up here doing everything they could with us, and some of those same departments now are getting some significant increases, and we're not doing anything for them.
Well, is there a particular level that you feel like that we necessarily,
No, I just don't see any indication at all that there was any communication or anything talk to the library about, you know, getting the $600,000 number. I think they just basically said, well, we know we're not going to get anything, and gave up.
So if you didn't have a discussion with them, when were they presented? They turned in that they wanted the 609, and then when were they presented that we were?
I don't know that there was any discussions about necessarily what the level of funding was that we have. We usually try to meet with all of the agencies and provide a letter, and then do a corresponding letter back to those agencies as far as what we necessarily spotted in some of that discussion. I don't believe.
So how did the 609 number get created or justified? Was that presented by the library?
I believe that was in a transmittal from them.
Typically, every year, the library, as well as other agencies such as Health Department, Public Defender's contract, Superior Court contract, DFACs, they come in as the budget's being prepared. This year, there was a delay in receiving the libraries, and I believe we got it the week before the budget was actually due. We typically use everything as a placeholder of what they got last year, and then when we got the request, that's where we, and then obviously they came to the last meeting and voiced their concerns over it.
But they had a budget calendar showing?
I don't believe so, not this year.
The other thing that's not as easily seen in these one slides is there is a drastic cut from what they proposed to what we proposed, the $200,000. But there was also from the initial, and I was trying to see if there was an overall in here of what was requested overall in our budget and what we proposed. There's a couple $1 million difference overall too. So it's you know,
before we saw it.
Yes, before you ever saw it. So we certainly cut other agencies too. I know you can see that one very easily because it's right beside one another. But it's not like everybody else got an increase. They're the only ones that did. There were certainly any number of departments from.
Steve, what prompted your concern with just the library?
I had some newspaper actually asking my thoughts on it.
Did you get any citizens?
Huh?
Do you have any citizens calling you?
Me, I'm a citizen, and I have concerns. I remember the library folks coming up here and actually working with us, and they very much wasn't happy with what we asked them to do, but they did. And so with some of these other things that apparently we're all okay with, all these increases, along with the merit pays and all that kind of stuff, why was that one? Because I haven't found any other ones that was held to exactly what they had last year. Did I miss any? Was there anybody else, any other department that was held to exactly?
Actually, yes, sir, we reduced a lot. If you look at, I believe within your first document.
I mean, held exactly, not reduced, but held. And the reason I say this is because it appears that there was no dialogue with those folks. I mean, it was just.
I can't say that it's to the exact amount, simply because, you know, especially if they have personnel, if, let's say, workers' comp increased, or taxes increased, or any of those just general items increased, where there wasn't necessarily an increase based on request, there may have been an increase based on mandate.
District attorney didn't agree. Do you think there's some ways we can be creative as far as SPOS with some of the capital things, or?
In the past, we've done several different things.
I know that doesn't help them, they want to increase staffing.
You know,
That would help that.
in the past, you know, in years past, I know that SPOS was used for different buildings. I know more recently, we use SPOS to do technology for the hospital. And so that certainly can be looked at, and perhaps one particular item or a series of items that were capital in nature that the board deems permissible, certainly could be done.
Judge, you're sitting out there just patient, and I know you want to hear about your department.
Yeah.
Can we talk about her a minute?
Absolutely.
What's your department number?
She's the
Four.
Page number.
Okay.
Page number.
I don't really have anything. I just was waiting to see if y'all had anything for me.
G17. Well, I got a question.
Is that a bingo number?
Cause I'm looking at your page, G17, and I see what you requested, but you're getting a lot more than you requested. I'm just wondering how that works.
I'm getting a lot more than I requested.
Well,
That's the 269 proposal.
Maybe you didn't get my request.
Well, it says you requested 269,000, we give you 275, I'm rounding.
Well, I can't go by that, Mr. Wendell. I need to know what you're talking about specifically the increase is.
Actually, you're looking at the top number of personnel. The total number is 292, 298.
It's $6,000 more than,
But still.
more than you asked for.
That was the original sheet that was turned in on personnel. Rose, correct me if I'm wrong.
I've sent it, wait a minute. Let's just go back from the beginning. I sent in 3 sheets, and I sent each one of you an email and asked you if you got the last sheet. I got response from 2 of you that said you didn't get the attachment. And I sent the attachment. I think Phil got the attachment. What I had a meeting with Toss and Joanna and Phil about was that I had turned something in that didn't get turned in. It was a misunderstanding, and we sat down.
We worked through all that.
We worked through all that, so I don't really know what he's talking about. I'm just saying, I don't think he has the correct sheet.
It's somewhat $50.
Go ahead.
The increase on the
Well, sometimes what she turns in, when HR gets it and they have these different increases, the numbers do go up, but it's not, because she's asking.
Well, I need to know what you're looking at. Can I see what you're looking at, please? Can I see on the screen what they're looking at?
That's what he's not.
What is he looking at? I mean, I'm not upset, I just want to know what he's looking at so I can explain it.
Is the change due to a mandate of some sort?
Yes.
That's what it is.
$6,000 due a mandate of how one of the fees are calculated.
Yes.
You said you were staying to find out if you were getting all your money, I was just trying to find out.
No, not here to argue tonight, Mr. Wendell. So
Cause see,
let's
I
don't try
hear
to pick a
about all
fight.
these conversations that's been held, and, you know, I just want, I'm curious, just like Steve, to know where these numbers come from.
Well, when I see what it says, I'll tell you.
This is where the chair was, I'm sorry, put that one right here.
Can you see it there?
No.
He can zoom
Here, how about
in. If you'd like to.
Yeah, I
you
can
go
see.
look at it.
See that?
Thank you.
This is what he's referring to here. The
Okay.
requested total is 292 versus what is it, 298?
Well, y'all, I don't turn it in like that. I turn it in with
And I'm
personnel,
not saying
so
that-
I don't know what you're talking about.
The difference is right here in personnel, and it's in these numbers over here, which is the difference in the increase in workers'
Okay,
comp. So it's not a difference in
It's in workers'
personnel,
comp.
it's a semantic.
She went to get.
okay, but what I'm saying is when I turn in a schedule and I ask for this person be increased to this and this person increased to that, and then I see those numbers, those don't match the numbers that are in my head, and I can't explain those numbers.
The other thing
If
is.
you want to look at people and their hours, that's what I can explain. Don't give me all these numbers like this. Good, that's fine.
Right.
Yes.
Yeah, increase
Yeah,
workers'
right
comp.
there, 77, 12, 50 right there.
What? But basically what happened is that my gun permits increased so much, I went from hiring an emergency hire, and then it turned out to need a full-time person.
Where's that number on?
And when I needed a full-time person, we cut.
Look at your second.
No, that's raises.
Yes, sir. There's a slight increase in some of the other ones. For instance, in payroll taxes, there's a slight increase in the retirement. There's a slight increase in several of the other ones, but the majority of the difference between requested and proposed is the COLA and merit, which is the 67,112.
I knew she was sitting here waiting to find out, so I thought
Yeah.
maybe if we could discuss her,
Okay.
if she wanted to go.
And you did pick up $10,000 more in revenue at year end, it looks like we just added.
That's correct. On the front side, you'll see that we originally slotted those functional revenues at 112. And looking at best year-end numbers and what we received, I believe that we could increase that by at least 10. We're currently at, I think, 134, and we still have to post June. So I felt like it was conservative enough to add that additional $10,000 in revenue.
That's another factor to consider there as well, is that some of these departments do produce revenue that are beneficial when we're looking at their budgets.
Well, I went from doing 6 gun permits a day to 30. That's a big increase.
Well, I helped with one.
I know. He did. He did. Mr. Wendell helped with one too.
Must not be very
My
tough
wife
reading
gets her
process.
way, she gonna get her one too.
But, and as long as that holds out, I need the increase, and if something happens, that's one of those things that could turn any time, you know, so.
Do you have any questions about that?
I really don't have any questions. Y'all have any questions for me? What we end up compromising on is having a full, increase to 1 full-time person and cutting my part-time to 20 hours from 25. I think she has been doing 30 sometime. But in order to not pay benefits, we shut her back down to 20.
So in truth, there was a compromise that we don't even see on this paper, because it looks like we're saying, we're giving her
That's
6,000
correct.
more than what she requested, but in truth, she made a original request that you guys worked with her on, there was a compromise prior to that, and that's not even being reflected in here.
Yeah, I asked for two part-time people at 30 hours
And that happens in
each,
other places.
so they could both have insurance. That's what I asked for, but I didn't know we weren't doing that as a county, so I asked for, I stepped back down
And at
to
the same
20
time,
and
the
40.
care law was still in limbo, nobody knew it, so
Yeah.
I think we were trying to hedge our
So I got the same amount of hours without having to pay 2 employees benefits.
benefits.
I think that was a good compromise. We appreciate that.
Okay. Steve, you got any questions?
No.
Okay, I told you I wasn't arguing with me tonight. Thank you.
Sorry you had to stay till 10.
Oh, that's okay. That's okay. Thank you.
Thank
All
you.
right.
Good night.
And she is available when she's on vacation, do you not?
Yes.
Yes.
You found that out.
Yes. Aren't we all? Vacation.
Is there any other department heads that have any questions about the budget? So, Steve, you've stated your concerns about the library. So I got a page of Reggie's concerns.
Yeah, we don't know about the budget.
No, but, well, the other thing.
Well, we certainly can look into looking at their needs, ask them to give us a list of specific needs that we could fund, and get back with you as far as our ability to do that. One of the things that we've said, that needs to be done in the next few weeks is to go through the short-term work program and look at exactly what we've done versus, what we stipulated this past year. And we may can find some funds within that area to help them and accommodate their needs.
So, I mean, with that, that's one that I found, and actually, I wasn't smart enough to find it on my own, pointed out to me. But that's just one that makes the appearance that we didn't do anything, and at the same time that we're increasing others and doing merits and cost of livings and all that, and not doing anything with this one that I found. It doesn't appear right, especially when they were some of the first to grit the teeth and bear through it.
Does anybody know the number, let's say theoretically, if we had a 20% increase in health insurance? How much is that?
I calculated a figure of 18, Rush, correct me if I'm wrong, based on what we're currently expending, if there was an 18% increase, it'd be about $612,000.
$612,000.
Just to give you an idea, I already know, you have a 6% increase federal taxes with healthcare in general. You will never get rid of that. That comes regardless what plan you choose and how you go to pay, and that will equal about $100,000.
How much?
$100,000.
And that's coming.
That's coming. That's already been calculated based upon the rates of and how many employees you have, your demographics, all that. That's all federal taxes.
Is that already in this budget?
No. I mean, we're still working off the number up from last year. But that's all I can verify at this point, because I asked them to calculate it.
So we know we got $100,000. We will have to come up with somewhat.
Or change the plan.
If we don't change the plan,
I
correct.
understand.
There's a lot more options than just.
We're asking for 8 options right now.
Well, that 6% is going to happen anyway.
That 6% is going to be in there, no matter what option we choose, it will be there, yes. And then we're asking for 8 comparisons.
Yeah,
Change the lot, build some roads.
Or change the plan.
That's what we're doing. We're looking every single option we can.
We don't have to take out roads.
But the 6% is what we're saying, don't have anything to do.
It's going to be, yes, that will be there no matter what. So we can,
You can save $100,000 by changing the plan. So it doesn't matter if it's coming or not, you still, we can do something
Bottom
else.
line.
bottom line, there'll be 100,000 somewhere that we've got to put somewhere, find a place for.
Well, y'all are smarter business people than I am, but there's no way I would run a business this close. we're taking another $61,000 out of fund balance. We got $100,000 from somewhere that's gonna have to come. We still got, there's so many contingencies out there. So yes, we're gonna realign employees, we're gonna do this, we're gonna do that. There's no way that I'd go to a bank and be able to borrow money to operate a business with a business plan like that. There's so many questions about this thing, I'm just telling you. But apparently, at least 2 commissioners have it all worked out and figured out, so.
Well, my perception is this year we had a change in the digest a little bit, we had a little bit of growth, and we're taking every bit of that and just spreading it out and doing whatever we can with it and not retaining a cushion of any sort.
Yes, they just took $287,000 of value off on some of my bills, and I've got 80 more over there, so if I went on all, I'm saying, I don't know that our digest has really gone up that much, but we'll see.
It has not gone up that much, and I think we said that in the original presentation, that it has not.
No.
Are we, budgeting extremely close? Yes, we are. There is no mistake whatsoever about that. As far as our ability to handle that, the reason I believe that we're able to handle that, and I will not say that we can do that more than this year, is because of the fact that we have those funds on hand, which is the 4.2 for operational, along with an additional $3 million in fund balance that is sitting there that we have for contingency. With those 2 items, basically that helps to solidify our operations rather than being out there and strictly budgeting all of our receipts versus our expenditure.
Plus $5 million in the special tax.
I really don't count that, and I'll say it this way.
I recognize that you don't.
I don't count that, and I'll tell you why, because that in itself is our rainy day fund for all of the rest of the unincorporated area. However, do we have additional revenue that's coming into that? Yes. Will we be able to solidify that for more than 3 years? No, not without the fire fund becoming self-sufficient.
But part of you saying you don't count that?
I don't count it from the standpoint of we can't use that against necessarily general fund items. The whole reason that we put that over there was so that we would have those funds for the unincorporated area. And to me, it's 2 separate pots of money.
But some of those things are included in this budget. Correct? And then we have water, and then we have money in impact fees. It would be a tight budget if you didn't have all of these additional funds. And I will say, I thought, I don't know which 2 commissioners you think have everything worked out, but I didn't bring my proper sheet, but I have done a comparison. I've spent a lot of hours on it myself to try to be able to, for my own vote, make a good rational business
Well, I'll say that as a compliment. I know you put a lot of time in this.
So I've compared the years from 2002 moving forward, and every one of those years was planned in such a way that we have very, very large amounts of additional funds coming in. One thing I did say was, that's not a proper thing to do with taxpayers' money either, is overcollect. So
Well, that's what I was going to say.
you want to budget it as tight as correct, as correct as you can, as long as you have.
That's what I'm doing, rolling the millage back. If we don't need it, then back it up.
I will say this, so I checked with Linda this evening, and then I think there will be a point where it will diminish. The new tax that we have on motor vehicle, she tells me that through the end of June, we collected almost $2 billion. Historically, over the years, we have collected about 1.3, 1.4. So that tells me that at least through the end of June, that we substantially have collected more that would show in last year's fund balance that just ended as of 6/30 than we have had historically for the last few years.
And that's great,
So,
except for the fact that we won't get sales tax revenue that is replaced by that
transfer tax.
The state estimates that's going to balance out with over a 4-year period.
And that's why I said, there will be a diminishing time of that.
And see, I guess one of my points is, when you have a history of how your financial planning has been done, if the person primarily responsible for offering those financial planning has been successful in those numbers for 10 years, you have a little bit of reliability in that if you're sticking in those same terms. If we had a brand new person coming up with a new scheme, there might be a different reason for concern there.
I understand, and I would differ maybe from Commissioner Mason that I don't like debt. I'm forced to have a certain amount of it, but I would rather be eliminating debt that this county has, because you eliminate debt, you eliminate interest, and over the course of a period of time, you get better off because you wind up with more money that you can use for something else.
And that sounds like a good idea.
And
I
the last,
I'm behind you.
I like getting rid of the debt.
and in the last 2.5 years, how much water and sewer debt have we eliminated? We went from roughly what to what?
Well, in the last 2.5, 3 years, we basically paid down the water and sewer debt by the $2.5 million that we used. We also, I think, paid off another $500,000. Plus just the principal alone would have been about $1 million, a little over $1 million, if I recall correctly.
And the write-off, the contractual write-off.
That was about 11 million five, if I recall correctly.
So we reduced it by about 15 million.
Or do we need to watch what we're doing? Do we need to make sure that we don't spend anything more than necessary? Certainly we do. That's in any given budget. But I do say the fact that we were wise in prior years of putting back that 4.2. You know, in 2006, 2007, I believe we had $700,000 worth of rainy day fund. $700,000, to operate the county on. We have increased that to the 4.2, which is about 15%. And we have an additional about $3 million on hand. And I think we've made some wise decisions as far as where we've cut different items. The fact of the food service that we did, the fact of bringing the roads maintenance in-house, cut another $300,000 or $400,000. I think there are some opportunities that we still have in some areas, though those opportunities aren't as large as perhaps in recent years. I think there's still some consolidation that we can do with personnel, but it is an ongoing process, and there is no easy answer to what has occurred in the last few years as far as the economics. I can only say that we have been very fortunate because of decisions made in the past years that we are not in the same boat as many municipalities and many counties. But that doesn't mean that we don't stay on our guard and ensure that we don't get in those same
And through the 2000s, as the digest increased, it was easy for a commissioner to sit on this board and hold millage where it was, because you had more money coming in. So it's easy to hold the millage because you've got this excess money to let things grow.
They were
We
increasing.
came on, and we were facing reduced digest every year. Very difficult. We cut all these departments, like I was talking about library and stuff. This year, we had a little bit of a spike. We've got a little bit of money, and we're doing the same thing that we talked about was done back then. We're taking that excess money and just applying it.
But like the 600,000, some of the funds that we're using, 400 of that was like put back. It's not, in other words, it was, can you explain?
We had a net increase in our fund balance of $395,000 is what we were suggesting to use. The current amount, depending upon whether or not some of what I've understood from the tax commissioner, we may be a little bit over that in the current year. We certainly are not necessarily budgeting in such a manner to create additional fund balance at this time, simply to maintain what we have.
we weren't reducing our fund balance by 600, even though we're using 600 because we increased it, so we're using a portion of it.
I mean, the points that Commissioner Mason and Mr. Kessler are making are points that everyone needs to be aware of. Then that there's not a fallacy in what we're describing or proposing in this budget. I think it's wise to be sure that we vet those particular issues.
And I agree, employees need to get a raise, so don't take this wrong. But where did that percentage come from? I mean, where did those percentages come from?
There are general percentages that have been used in the past. If the board wishes to make changes in those percentages, we certainly can do that.
It was something personnel had looked at in the past, is my understanding.
Doesn't it work out to 1% per year overall?
There is a calculation. You can use inflation-based, you can use average. We try not to keep you at private industry. We're very, very behind private industry. Private industry is usually 6 to 8% right now.
Is what?
Some of it is as high as 6%. Now this is national, it's not local. We have one of the highest unemployment rates and the slowest comebacks is in the southeast of the United States when you look at the overall numbers from the Department of Labor. So what you're seeing is that even though the Department of Labor nationally is saying that we are creating more jobs, that they weren't in the southeast at all. And actually this area, coastal Georgia, was one of the slowest comebacks in the entire state. So we did use 3%. That has been used in the past 1% a year, or almost a little actually less, because we did 2010, 2011, and 2012 is what we put 1% a year on that COLA. That is nowhere near what inflation actually has done. And then just the 2 base merit raises, what they've always used. That can be adjusted, but then again, that was only configured on a 6-month basis. That's only configured for basically January to June of next year. So it's halved at this point. So, does that answer your question a little bit?
I don't know what you mean by that.
We did not give merit for the entire year. We did not let merit come into play until January 1st of 2014. And you also had to be employed at the county for 1 full year on that date in order to be eligible. So it's technically, it says it's at 2%, and it is at 2% for those who are eligible, but it only, it doesn't start till January.
I didn't even know that until this minute.
Surprise.
I don't know if that's in the document somewhere, but I missed it.
Yeah, it's only calculated January 1 forward.
So we're not really giving 5% increase for a year. We want to be sure that's reported, right?
Correct, you're not giving 5% increase a year.
Calculate less.
Yes.
And there is an option with any of these items that this board can hold back, subject to your wishes.
I recognize they're all tough decisions because there, as I've stated before, there's just so many unknowns that that's why they call them unknowns. You won't know until they get here.
They are unknowns, and a lot of this is preferenced on prior discussions with each one of you as far as trying to do something for the employees this year.
And I think it should be. I'm just trying to figure out where that number.
Yes.
I mean, in theory, I would rather balance the budget without having to take money out of reserve.
Certainly I would also, sir.
I would like to do that. My theory of taking money out of reserves is for these things that come along that are unforeseen, that make it necessary to take money out of reserve.
Or generally it's reserved for items of the capital management.
I understand. But whenever I'm sitting here, and I mean, these are, we approved something $4,500 for the chamber. It's not in here. It's so it's gotta go there somewhere, right?
I believe in looking at that agency budget that, there's one item in that agency budget that I believe, we aren't spending to that particular level, and that's on the travel, that's what the,
We got $100,000, but probably gotta come from somewhere.
Or
Yeah.
have to renegotiate, or we gotta find a way
And
to
see,
pay for it.
and I understand employees won't, because most employees see what's in the check that they get. You know, you can cut benefits and you can, you know, raise percentages and, you know, in a lot of ways, they're a lot better off that way to keep.
Keep their base head.
Yeah, so, I personally just don't like balancing a budget with these unknowns already known using fund balance.
yes.
Unless
We,
you're
we,
from Allen.
so we've got two options, either cut the budget down,
Well, I was trying
or raise the millage and replenish
Or unless
the
your
reserves.
balance is high enough of a cushion to do that.
And I was trying to get another $300,000 out of fire fees tonight, y'all wouldn't give it to me. I was trying. See, I had it figured out, but you wouldn't give it to me.
But you know what, frankly, I had a good idea, there were a few good ideas brought up that still could be implemented.
And we certainly will look at those revenue sources, you know, in the past, it was my understanding that we could not do that, but I assure you tomorrow morning we will be looking
Like
at
on the
that.
building permits, that's probably
Yeah,
something. that-
fire fees last year were raised for the first time in how long?
We've got to change the order.
We had raised them from, I believe, 35 to 55, if I'm not mistaken, last year. There had been some discussion
But they
about
had been
that.
35 for a long
For a
time.
long time.
So we started that, I know it's not a big giant step, but
Everybody agrees.
They were way out of
Still
our
our
line.
this year, I'm telling you.
They still are out of line, I just don't think you can do it all at one time. You can, but.
And that's where we're moving. We're moving towards trying to build this to where we are not so reliant on one or two areas, that it is more fee-based, so that people using those particular items are paying for those particular items. And I think we've made great strides in the last 2 to 3 years to do some of that. We just haven't been able to do it all at one particular time.
And that's one issue with the timber ordinance, was there was no fee associated with administering that.
Because state law allowed you to charge for it. All right, so where do we stand with this budget?
Yes. State won't let you.
To me, there's one.
You can't charge HOA fee for a permit.
It's illegal.
To me, there's one item that we would need to also amend, and that is the 4,500 that you just included, is to amend that one line item within the agency budget of Department 51, which it would come then from, I believe we would have enough in the transportation line to move 4,500 from the transportation line down to the chamber.
And what I'm telling you is, you see, she just found 4,500. I've seen that happen over and over.
Mr. Meyer's request also.
Sure.
What he was
There's
alluding to
400,000 in there.
that we didn't have to maintain the current 7.7 system because it's not operational.
I can't hear.
The request that Mr. Meyer was asking to add, that'll be back on the or the special call meeting. I was trying to find the actual document here. It's right. What they determined is the 7.7 system, which is the one that's not operational now, the one that went down, is included in that agreement also. He has requested an additional one, and it's right at $60,000 less. So if the board chooses to approve that agreement, there'll be about $60,000 savings in that 85 that we added in. We won't need all 85, but we'll only need about 25. So we will pick up roughly $60,000 there. So the 4,500 would come out of that. And if you wanted to put more, you can reduce your fund balance, you could.
We just gave back about $27,000, $28,000, as I figured it, in that tax refund.
but she's not budgeting what we may collect in taxes and arrears. That's a whole bunch of pot of money that we've been able to use in the past also. That's the kind of stuff that he's not aware of. What item number is this?
If we were to, tell me again about it. If we were to come up and decide to spend $1.8 million on development on our communication, and then that budgeted over so many years, I mean, payments, how much about is that dollar figure?
We basically had tried to talk to them about extending that over a period of 5 to 10 years so that it would actually cross more than likely 2 SPLOST fundings.
If we're lucky enough to get it passed again.
Yes, sir. We basically had done that with the 911 equipment where we had gotten them to actually lease that at, I believe it was at a 10-year term. And so our hopes were in that discussion, I believe you were in that meeting, to try and get that over a 10-year term. So you would be talking about the 1.8 divided by 10, hopefully. And then we would need to look at the short-term work program and perhaps rearrange some of that. I know that there's some consolidation talk as far as some of the fire and the possibility of reworking some of that, which would free up possibly some of the capital slotted within the fire area. I do believe that we need to look at roads though. That's one of the major concerns as far as exactly what projects we have slotted versus the direction that the board wants to actually appropriate funds.
And how much money again do we have in impact fees available that's going to be spent somewhere?
A little less than $1 million, I believe.
It's a little less than $1 million sitting there, but we also have the stuff at the Parkway that we need to act for reimbursement on, it's about $1.5 million.
$1.4 million something.
So overall, about 2.5. Or 2.3.
Another 1.5 that will be available, is that what you're saying?
It would be reimbursement for funds that we have already paid
If we
under
can get
that
that,
federal
if we can get
earmark.
that back.
Right.
But we have $1 million in our hands.
Yes, ma'am.
Okay. So before us is our consideration to approve a budget ordinance for fiscal year 2014 as presented.
The ordinance itself and the appropriation of funds, yes.
Yeah.
And did you say if we were to make that motion, that we need to make a motion to make that $45 million change within the same motion or different motion?
You have the second draft that was presented tonight. The 4,500 would be an additional change to that second draft. And I would say that we would need to slot that out of the Department 51, moving it from the line item of travel down to the chamber line item.
Travel or transportation?
I'm sorry, transportation.
25,000, take 4,500 from 25,000.
Correct, yes.
If this board is ready to take such action, I'll entertain a motion.
I'm going to attempt the motion as what was said, and please correct me anybody who think that I'm missing the gist of it. I'd like to make a motion that we approve the second draft that was presented tonight with the change of taking the 4,500 in Department 51 and moving it from the transportation line item to the chamber line item.
Correct.
That's my motion.
Do I have a second to that motion?
I'll second.
Motion and a second. Any further discussion before we vote?
And with the addition of the verbiage changes that y'all brought up earlier, I mean, it's nothing changing the budget, it's just some of the things we had some.
All the typos.
The typos, yes, sir.
To the other.
Yes, sir.
I think that's it. Item of business, item number 14, consideration to approve a corrective action plan for fiscal year ended June 30th, 2012. Is there any changes to that corrective action plan?
No, sir, not the one that y'all were given last meeting, I believe.
We did do a synopsis for you on one of those pages as requested.
Is there any reason to believe by staff that this corrective action plan cannot be followed in a manner that will correct any deficiencies that we may have had in our audit? Did you understand the question?
No, sir.
Is there any reason for any staff to believe that the adoption of this corrective action plan and the actions taken as outlined therein would not rectify or solve the deficiencies that we had in our audit?
I believe that it will put the policies in place to regulate the things that y'all brought up, or to specifically address them. Now, whether it would preclude any further action or audit findings in the future.
Oh, we've already had new stuff that'll come up. That's, I'm talking about the issues that were brought up. These should take care of those.
Wouldn't make them right, it would just prevent them from happening again,
Okay.
It's the corrective measures.
And we are, as staff, working on adoption of policies and procedures to present to this board that will correct deficits that we have in those policies and procedures.
Yes, sir.
Yeah, and as stated in the plan, that was within 60 days, no later than 120. The plan is, 15 days old now. So.
Okay, because all that's in here, I just want to be sure we are in fact doing that.
Yes, sir. And I've already made the preliminary steps that you've asked for behind the scenes.
Are they close?
Yes, I actually have them here with me tonight.
Okay.
So, one more bit of discussion tonight is, I don't like this. And I don't like the fact that we didn't include Crowley's responses or any part of it in it. I'm still not happy with the way the audit was done. Particularly, this item number 23, the apparent conflicts of duties related to the marriage.
Well, that's what I was about to say.
Fact is, one didn't work for the other. So
It
our
didn't
response.
It didn't seem that way. I mean, it was
It
fine,
no.
wasn't it?
Fact was, one didn't work for the other. So this response is actually not correct. The response should include that it was clear that one did not work for the other, and further, that this is something that had went on for years that wasn't in the audit. So these responses, there's more than that, but that's probably the one that's the most clear.
We actually had Eric draft that particular response to ensure that it was in conjunction with our stated policies.
Well, if you look at the HR policy for both of those job positions, there were actual requirements that stated the clerk would report to the administrator in order to prepare the agenda and certain items. So there were specific things listed in the job descriptions that said she did report to him on those issues.
I'll just tell you my position on it, because I looked at the personnel policy. I don't think that the audit finding was technically correct, that our current personnel policy prohibited that relationship. I don't believe that our current HR policy prohibits it, and that was the reason I brought it up with Cost and Joanna as corrective action plan, because in essence, the first draft of this said we already have a policy that deals with it. My position is we don't. Previous boards certainly were well aware of what was in their personnel policy, and they certainly did not believe that the policy the same building. And that may be something you want to look at.
It talks heavily about relationships. I don't have it with me, but gosh, it talks about this types of relationships.
It talks about relationships between people in a direct supervisory position with the authority to hire and fire. You know,
There was a
talks
conflict
about
of interest, in my opinion, and that's the bottom line. And we need to address it in our.
But it's not, it
But
should
the
be.
senior personnel policy
Yeah,
already
personnel
addresses.
issue, then address the personnel, but that, it shouldn't be an audit finding, and with that, it shouldn't be, I'm not going to be wording the way that this is being responded.
To say your HR policy already addressed it, in my opinion, is incorrect, because it didn't specifically address it. It left a gray area. I think this board needs to revisit it, and you have to decide what relationships, and define more clearly what relationships may be allowed and what relationships are not going to be allowed.
Yeah, and I don't have the wording memorized, but it addressed not only people that manage each other, but in any scenario where one person working within the county would have a relationship that may skew their decision-making. It addresses it.
In a checks and balances role. Maybe not directly.
I'd have to have a policy, and I'd be glad that we can bring that out at the next meeting if we need to.
I think that's why when Eric and Toss and I were talking, we deferred to the particular language that we used within this corrective action plan because of the fact that it needed to be more addressed necessarily by the board. And we incorporated that language that Eric suggested and actually wrote for that particular section to address.
If it were already crystal clear, we wouldn't have two commissioners on that side of the room saying that it's crystal clear, and a commissioner on this side of the room saying it's not prohibited. And so my feeling was the best thing to do, if you have to do a corrective action plan, part of the corrective action plan should be.
And further, I had Donald King, when Donald King said to me that the reason it wasn't on an audit before was because previous boards allowed it, and he didn't put it on the audit, that means that his audit was flawed for the last two that I looked at, and the ones before that. And so now it's something that we need to have on the official audit, not just something that, okay, laws have changed and the board needs to make some change and move one somewhere or do something, rather than let's just fire two people. And that's what we did.
I know what we did.
Sure it is.
It is to your opinion, not mine. There's an obvious, clear.
This was something that was
So
decided.
we had a husband and wife team basically run this county. That's ridiculous. You don't find that anywhere.
Again, that would have been a great thing to bring up in personnel discussion, not to have a discussion among two other board members between meetings.
This is an issue that we're not going to resolve tonight, as far as opinions.
Let me add one thing that has nothing to do with those two positions, but one of the points of discussion we had when Joanne and Toss and I discussed this particular finding was that we have had a lot of movement of other departments under one roof. And so we now have multiple departments in this building that we didn't used to have. And the current HR policy does not prohibit relationships between people who may be working in the same building under the same roof. And that's one of the things, I'm not telling you you need to have a policy, but I think that's part of what your review should consider. Because you do have, I think there's been an effort to reduce the number of buildings the county has and pull people into centralized locations. And so there are more and more opportunities for these issues to occur. And that was part of the reason to include in this response that we're going to review the HR policy. So it wasn't just one thing, it was multiple issues that got us to the language in this one comment on number 2012-23.
But if we review the policy, define it, and get some definition, then we're not gonna fix the debate over whether this was right letter, this was wrong, but we may fix the situation so that it doesn't happen again, right?
Well, we've already,
Basically, if you've got a county administrator, he does not, you don't need to have anybody that's related in any way to the county administrator if they've got any type of hiring and firing ability or management ability, because in some way, they can,
those are decisions the board has to make. Another one of these findings had to do with other related party transactions, and I'll tell you, we already had at the last meeting, 3 contracts on your agenda for HVAC, plumbing, and electrical services. And they were originally drafted with a clause that simply prohibited, quote, any interest. No commissioners will have any interest in the agreement. Well, we don't have any set policy on what an interest is or what a related party is.
There's a state law,
There's
state issues law. No?
the state, there's several state laws, but, and I'll be glad to recap at workshops when we go through all this. But we don't have any definition of what an interest is. I went through it and I went back to the ethics policy, which the board repealed, and I took the definitions from the ethics policy and plugged them into those contracts so that to simply say no commissioner shall have an interest, doesn't, financial interest, some other interest.
You're saying that's too broad.
It's too vague.
I agree with that. I agree with that.
We all should have an interest as commissioners, at some level, I mean.
Sure. So,
We're all taxpayers.
Well, I mean, when I was reading that thing earlier, you could make an argument, say, I'm not picking on it, but that we could buy power, North Power, because Forest Ford works for them.
That's different.
I mean, that's stretching it out there, but any interest. So I think you're right, that's too broad.
a cousin,
But there's a
stepbrother.
state ethics policy that lists actually which relatives and the whole 9 yards. And you're saying that-
There are different policies. There's rules for zoning in the state law.
Correct.
There are some rules for purchases when the purchases exceed, I think it's $800
A quarter.
per quarter. But that talks about a direct interest. In other words, where the commissioner owns the business. It doesn't talk about cousins, nephews,
Sons.
correct. So,
Spouse, I think it was.
doesn't,
It was spouse.
oh,
well, the
So
point is,
your
there are lots of
recommendation-
different definitions. There are lots of areas where there is no definition. For purchases, there are some definitions in the state law. As we go through these policy considerations, my recommendation is going to be to have a uniform, consistent set, which is actually what we had in the ethics ordinance. Maybe we don't need those things in an ethics ordinance, but we obviously need policies. Maybe they need to be pulled from the ethics ordinance and put into the financial policies. But we have to have something to go by.
Or within the purchasing policy, so it's clearly defined within the purchasing policy that people view on a daily basis, and they understand, those department heads understand those rules and regulations. And I do agree with Eric that some of the law is very vague, and it's referenced in several different places. One, may say family members, the other says that family members are to include X, Y, and Z. And so having it, written down within our own policies, within the purchasing policy, certainly would help significantly.
So include it in the policy you're about to present to me.
okay. I would love to entertain a motion on item number 14, consideration to approve the corrective action.
I'll make a motion to approve the corrective actions presented.
Second.
I have a motion and a second. All in favor? Any opposed?
go to the executive session? Is there
Yes,
anything?
we got one.